with you, the participants in the course, the key factor for its success. But before concluding my intervention, my opening speech, I want to leave you with a personal thought or perhaps a wish. Europe is in need of more innovation and, importantly, the capacity to bring that innovation then successfully to the market. This is a clear message that is strongly emphasized, has been strongly emphasized recently in the Draghi report, which has been published just a few weeks ago. As often as well underlined by the President of the European Commission, Ursula von der Leyen, enhancing the EU competitiveness and therefore boosting innovation will be among the European Commission key priorities as well in the coming years. So I'm fully convinced that intellectual property will be a critical tool in this effort of the European Commission, of the EU institutions. And therefore, EU will need more than ever skilled and passionate IP professionals who understand the full potential of IP. And I would say, not just as a legal safeguard, but also as a valuable business asset and as an instrument to boost innovation. So my wish, if you want, is that many of you will be those professionals, will be the professionals who will be helping European businesses and entrepreneurs thrive, both within the EU and as well in the global stage. My hope is, therefore, that your knowledge and expertise will be one of the driving forces behind Europe's future competitiveness and success. So please enjoy your classes, participate fully, and make the most of these learning opportunities. Thank you very much.
Thank you very much, Mr. Di Carlo, for this introduction to the program. Now, before we start with the first session, I would like to go over some important groundskeeping details that will make both your lives and our lives easier in managing this big event. So first, if you have not already done so, please rename yourself according to the instructions we provided, which basically means we need you to have in your display name on Zoom your university name, followed by a hyphen, and then followed by your name and your surname. This will help us basically confirm your attendance and ensure that the registered participants are connected. So using names like mobile 526 or tablet 247 or Terminator will not be acceptable because we will not be able to identify you, and thus we will not be letting you in the session. And you're gonna spend time in the waiting room for no reason. So please make sure that you rename yourselves according to these instructions. And then in relation to the attendance certificate, the requirement is that you attend 70% of the overall sessions of the EUIPO intensive program. If you attend 70% of the program, you will receive a participation certificate. We also provide access to our learning plans, which we consider to be highly important as supplemental materials to your learning. You can access these learning plans via the Academy Learning Portal. You will have to create an account. It's free of charge, and then you get access both to the learning plans specifically that we provide access via the intensive program, but as well in a lot of other courses that are, again, are free of charge. And then we also recommend following the learning plans by our colleagues over at the European Patent Office via the e-learning center, which is basically giving supplemental material in relation to patents. Now, during the sessions, you can ask questions using the chat function or raising your hand at the end of each session, and then we will give you the floor, again, if time provides, if time allows, to ask any questions that you may have. In the meantime, if you have any issues, if you have any questions, you can always reach out to us at eventsmanagementacademy@euipo.europa.eu. And then I'm here with my colleagues, Yorgos and Tom, and you can send us a message directly, and we're going to try to respond as quickly as possible. So with all of this out of the way, and before we go to more of a substantive session, we thought it would be best to start with an introduction to the EUIPO, explain a bit what the office is about, what we do here, how basically we're structured. And to do that, I would like to invite my colleague Damian Pornas, to give us this introduction to the office. Damian is an industrial engineer and is currently working as a research administrator in the Economics and Data Intelligence Service of the EUIPO. Before working in the EUIPO, Damian worked for 12 years in several Directorate Generals of the European Commission, such as the JRC, RTD, Connect, and the Executive Agency INEA in Brussels and Italy. In these positions, Damian has participated in the elaboration and implementation of several EU-wide policies in the fields of industry, innovation, energy, and technology. So, Damian, welcome, and the floor is yours.
Thank you very much, Alex. Thank you. Can you please confirm that sound is okay? Can you hear me well?
Loud and clear. We can see you, and we see your PowerPoint.
Also my presentation. Very good, very good. Okay, so
full screen.
everyone, it's really impressive seeing that that we are more than 300 people in this event. So congratulations to my colleague in the academy, and also welcome to the EUIPO. As Alex was saying, my name is Damian Bornas, and I work in the Economics and Data Intelligence Service in the EUIPO. So today, I have.
I'm sorry to interrupt you. We cannot see it in full screen, your presentation. So if you can just put
No,
it
no,
in full screen.
yes, yes, I know. Okay, I put it now. Okay, now it should be correct. Okay.
Yes, thank you so much.
Okay, thank you for telling me. So as I was saying, today I have prepared a very short introduction to the EUIPO. Obviously, I'm going to highlight the main features of the EUIPO. So the EUIPO is much more than this, but I have only 10 minutes to tell you. And for this, I have prepared a presentation that is split in two parts. First of all, I will introduce you the organization. And secondly, I will explain you a few features that may be interesting for you. Okay, for you, for your organization, for your future plans, and so on. Okay. Okay. So I mean, this year, the EUIPO is turning 30 years. 30 years. So we started in 1994 with 5 colleagues, and today we are more than 1,000. And so the idea is that the EU institutions created the EUIPO with the aim to remove legal barriers that were hindering at that moment the development of the European Union internal market. So the whole idea here is to facilitate exchanges between the members of the European Union. So as I said, we are in Alicante, but we also have offices in Brussels. I didn't know we have one in Luxembourg, but some colleagues told me that we do. What we do here is basically registering trademarks, designs, and also geographical indications. Okay, so the latter is something very recent, and I think that the first one will be registered around December or so. So as I said, we are part of the EU institutions ecosystem, and our official languages are English, French, German, Italian, and Spanish. Okay, so our working languages. My colleagues, I've seen the program and it is very complete, so I will not give any details about intellectual property. Some colleagues are very, very experienced, but I just wanted to give you some examples of what we do. And when we mention, when we say European Union trademarks, what we mean is what you have in front of you. We are registering word marks, figurative marks, shape marks, and so on. Okay, so these are the trademarks, the types of trademarks that we are registering. And when we refer to community designs, here again, you have some examples. Okay, so these are examples that will be actually developed much further in the coming 10 days. So, maybe it would be interesting I say something about our organization. So our organization is made up of 14 departments, which are grouped in 4 clusters. So each cluster is a group of departments that have some common objectives, and they work together to reach these objectives, which are obviously part of the overall objective of the office. We have one executive agency, one executive director, which is Mr. João Negrão, and his management team is part of 2 deputy executive director. One is Mr. Di Carlo that opened this session, and the second one is a recently selected deputy executive director whose name is Mrs. Edita Dembisiwek. She will be starting very soon as our second new deputy executive director of the office. This is our organization chart, but above this we have 2 governing bodies. We have a management board and a budget committee. Each of these governing bodies are made up of 1 representative of each EU member state, so 27, plus 2 members, 2 representatives of the European Commission, and 1 representative of the European Parliament. Okay, so these are 2 bodies that meet twice per year, and they decide the main strategic lines of the office. Okay, so this was an introduction about the organization itself. Here in the second part, I wanted to give you some resources linked to the EUIPO that could be interesting for you. And the first one is the SME fund. So in the policy of the EUIPO and also the EU institutions, SMEs are key for the economic development of Europe. And as such, the idea is really to facilitate this development of SMEs and growth towards something that is further than an SME. And for this, the EUIPO is working since several years on the deployment of the SME fund, which is basically a number of activities that have as an objective supporting IP questions within the SMEs. So one of them is a line of grants, which is actually open this year until the 5th of December, if I remember well. So if you want to, if you are interested, if you would like to know more, please come to the EUIPO website and you will have a lot of resources on the SME fund. The second resource I wanted to mention is in the website of the observatory. So the observatory is one department in the EUIPO, as for instance, my department, Corporate Foresight and Strategy, as the Academy, the department that is organizing this huge event. So the observatory is one of the departments that is in charge of managing a network of intellectual property stakeholders. Okay, and if you go there, you will find a lot of studies on the impact of IP, what happens with the companies that use IP versus those that don't have IP or that don't register IP, and many other things. You will be able to know more about the infringements. You have a lot of information there. So please, if you would like to know more about the infringements and the impact of intellectual property in economy, please go to the observatory website. And finally, as we are surrounded by very young people in this event, I also wanted to tell you that you have the opportunity to become trainees. You have the opportunity to become trainees in the EUIPO. So we have a program. Trainees usually start in September, and the traineeship lasts 1 year, so from September to September, and basically you are working with us, and I consider it is a very interesting opportunity for you to learn about the work environment, IP, the EU institutions, and many other things. So if you would like to know more for next year, obviously, because the last trainees have started only 1 month ago, I think that this year we have about 100 new trainees. So go to our website and you will be able to get more information. And basically, this is what I wanted to tell you. Obviously, there is another great resource in our website, which is the website of the Academy. Okay, Andrea already mentioned it. The colleagues of the Academy are presenting the event, so I guess that they will explain more. So thank you very much. Thank you very much. It is a pleasure. If you need to contact me, I put my email. If you need to contact me mainly about a question related to data, IP data intelligence or IP foresight, because for other questions, I guess you have better contacts in our website. So if you have any question, I will be pleased to take them if our moderator allows. Thank you very much.
Thank you so much, Damian, for your presentation. And I hope that everyone is now a bit wiser about what the EUIPO is doing. Actually, we're perfect on time. So I think it's better to shift now and to really deep more, let's say, in the intellectual property part. So I would like to invite our next speaker, and we'll shift our focus, as I said, to IP rights now in the European Union with Giulia Priora. Giulia is the director of the Nova IPSI Knowledge Center on Intellectual Property and Sustainable Innovation and assistant professor at Nova School of Law in Lisbon, where she teaches intellectual property law, legal research methodologies, and EU digital policies. Her main research interest lies in IP and sustainability theory and practice, distributive rationales in IP law and EU copyright law. Thank you so much, Giulia, for being once again in our events, and the floor is all yours.
Thank you so much, Yorgos. Thanks also to Alex, to Tom, to all the organizers, and I think all the team also coordinating behind this impressive effort. And welcome everyone also from my behalf. It's really a huge joy to be part of this program. And even though starting from now until the end of the course, you will be learning and dealing with everything that is intangible. One thing that is very tangible right now is my honor and also a little bit of pressure of being the first speaker. So substantively, I'm the one introducing you to the concept and the discipline of intellectual property in the European Union. So that is a responsibility, but I'm really glad to take it on. So let's dive in. I'll just share my screen with you, and probably Alex or Georgios will confirm that you can see it full screen.
Yes,
and
perfect. Yeah, thank you.
Great, thanks, Georgios. I have prepared for you a rather short presentation because the topic is so vast that it will take you a whole course to really grasp what intellectual property is in the European Union. So my presentation is short, and also my time. I am Italian, as the accent reveals to you, even though I'm based in beautiful Portugal. But I do tend to talk a lot. This is something I will try not to do. I'll just give you a little bit of a glimpse. And then at the end, if we have time, if the moderators allow, I'm happy to stay and collect some questions. So as I said, let's dive in. I have no spoilers for you today. I'll just reveal upfront what I'm going to present to you. I will try to synchronize us all in the room. over the concept of intellectual property. And then I will give you a few information about why we talk so much about the rights in intellectual property. And then I will add up to that, telling you why we talk so much about European Union and intellectual property rights. So the third part of my presentation, which will come up very soon, is divided into 3 boxes. I'll give you a little bit of historical contextualization, and then I will draw the main line of your knowledge, trying to make very clear what we have in IP rights as full harmonization of the law and those that are partial harmonization or missing harmonization. So let's get all in sync. What is intellectual property? It's a $1 million question for many students of mine. In intellectual property, because you will see that I will have 2 points in the presentation where I come with my bias. Okay, I am a copyright scholar. I started studying intellectual property and getting passionate about it from copyright. And you will see later on that I also display that I love Lisbon as a city. Okay, so I start today telling you that intellectual property is not only but also about copyright. Now, if we were in a face-to-face room and less people, because we are almost 400 people, I will ask you now to intervene, but I cannot, because I will ask you what is also intellectual property that is not only copyright. And the answer in the room most likely will come up very quickly and say, well, all the rest is what we call industrial property rights. And in this box, even though copyright and related rights is a box that has a lot to tell us, but in this box of industrial property, we have even more disciplines. And all the disciplines you will be covering during the course are part of this slide. Okay, so the whole picture you see is intellectual property. Inside industrial property, we do tend to encompass and to put patent law, industrial design law, trademark law, geographical indication, plant variety, also trade secrets to some extent, and other non-traditional IP rights. Now, if this whole slide is intellectual property law, what we are focusing is pretty much everything, but everything is not enough. We are ambitious students, we are ambitious people, we want to know everything. And one thing that we will not have time to cover, but I want you to keep in the back of your mind, is that intellectual property is a vast legal discipline. And is a legal discipline that is not an island, is not isolated from other disciplines in our civil codes, in our criminal codes, in our legal systems in general. And that's why I put these slides together. While learning about intellectual property law, rules, and practices, I invite you to keep in mind the fact that we need to fit these rules within other important disciplines. Let's think just out of mere examples of competition law, platform regulations, data protection laws, consumer protection laws, but I could go on and tell you that intellectual property has beautiful, fascinating overlaps and intertwinings with constitutional law and criminal law and theory of law and philosophy of law, okay? So anything that is your passion in a legal or cross-disciplinary perspective, just don't abandon it in your head and try to connect the dots with intellectual property. However, our focus is on the center of the slide, is on IP. And IP in the European Union, I couldn't find a better way to present it to you as our protagonist, as IP is first and foremost a fundamental right. And that's not me saying that, that's the Charter of Fundamental Rights of the European Union in its Article 17, paragraph 2, that tells us, and I'm quoting, intellectual property shall be protected. We could talk for hours about the wording of these fundamental rights and why the sentence is so short, why we're not saying more than this, why we're not mentioning each intellectual property right, but we consider it as a whole. But the real important takeaway of this slide is the fact that at constitutional level in the European Union, we consider intellectual property something very important. But if intellectual property as a concept must be something regulated because it's so important to defend it, right? And to make it part of our fundamental values, then let's start looking at how we regulate it. And in order to disentangle that, we need to understand that regulation about intellectual property in the European Union is really trying to tell us and guide us about who should be protected, what should be protected, how, meaning how much and for how long and under which circumstances we need to encounter intellectual property protection. Now, all these questions that you see in the slide are basically the little subchapter of each intellectual property branch you will be studying. For design law, for trademark law, I'm pretty sure you are starting with the trademark today, but for each block of this course, you will have to tackle each and every one of the questions you see in the slide. What and who we are protecting, how, for how long, under which circumstances, do we have any exceptions of this protection, okay? So this gives you a little bit of structure. But again, I'm being very general and giving you concepts that are still floating in the air. So let's try to concretize a little bit. Intellectual property is not just a fundamental right, something you probably already stumbled upon in your daily life, but it's a very essentially a matter of rights. And that's because, actually not because Article 17, paragraph 2 of the Charter tells us so, but because every one of us, consolidated doctrine, has been talking about intellectual property rights as a bundle of exclusive rights. And this expression is very useful, very important. It's not only legislation that regulates intellectual property by way of rights. We see sometimes it's not just about rights, but understanding IP as a bundle of exclusive rights really streamlines our knowledge. Now, a bundle of exclusive rights, first of all, over what? Over anything that we can demonstrate and we can consider an original output of an intellectual human effort. And also over the identity in trade. This little remark is needed because you are studying very soon about trademark law, and that has this specific characteristic of being a bundle of exclusive rights over identity in trade, which sounds a little bit different than original outputs of an intellectual effort. But let's say that even in trademark law and in all the other branches, we have human people, we have human beings really making efforts of intellectual character. The intellectual work is the real root of intellectual property rights. And we have a little third dot in the slide that says we give a bundle of exclusive rights also to some specific resources in society that are super important for us. And this is a part of intellectual property that sometimes is a little bit neglected, especially in introductory courses on the discipline. But it's also important because we have a malleability of intellectual property that is something very crucial and potentially very useful for society. Let's think of, for example, softwares and databases. These are resources that came up in our human history pretty much recently, and we used intellectual property to make sure that those people creating those resources were protected and could make all the returns over their time and cost and investment actually very practical, a return on investment that was very needed in society at the time. Now, a bundle of exclusive rights. I'm still not telling you which rights we are talking about, but I told you over what we can claim these rights and who can claim those rights. Now, this is also an important guidance I'm giving you for the whole course. IP rights can pretty much throughout the IP branches can be acquired in two ways. One is the original acquisition of IP rights. So this is very much inspired by the copyright legal doctrine, but for every IP branch, for every little box you saw in the initial slide of IP, you can be the person that did the intellectual effort that was required to put together the output, and over that output you claim IP, either automatically or through a registration process. Or you can be the person that didn't do that intellectual effort, but acquired IP rights because they were transferred to you. So you were part of a negotiation, of an agreement, of a contract, and some IP rights were sold to you or left with you exclusively. And you in this case are the derivative acquirer of IP rights. Now, both these rights holders, that's the right wording that we use when we talk about IP, especially when we don't know if we are talking with the person who did the thinking and the creation or the invention behind it, or the person acquiring those rights. All the right holders are the person we are trying to protect and to give those rights, to use them. The exercise of IP rights is the real deal, the real living part of IP. And finally, and we are getting to the more substantive part of my lecture, this bundle of exclusive rights can be split into two. We have a moral rights part. So we have, again, in copyright, this is very visible. We have some moral rights that the IP right holder or copyright holder, in this case that I'm bringing you as an example, acquires automatically and sticks with, and those rights stick with him or her even beyond the duration of economic rights. And these are typically some rights that have a little bit the flavor of personality rights sometimes. And on the other side, which is something that if you are a practitioner or you want to become one, is really the big bucket of information you need to get familiar with. We have the economic rights, also known as exploitation rights. The rights that we can trade and change and assign and transfer and license, very important word, license. Now, both these dimensions are very important. I hope these slides will make more sense to you over the course of the next sessions, but please try to always find a structure when you deal or disentangle or play around with all the rights you will be studying about, okay? It's always a variety of them. Now, why I'm saying that I'm really focused in giving you a little bit of conceptual structure, because it's not just a variety of rights that we give to a variety of people, but this is also a bundle of rights that over the centuries and over the decades has been expanding. That's why you see in the background of the slide the metaphor of a tree, right? A glorious tree, a flourishing one. Intellectual property is also a story, a legal discipline of rights that have really been enlarging their scopes and encompassed new activities, new professions, new people in society. And it might get a little bit alienating for you to really juggle with them all. That's why try to take your notes in a structured way. That's my personal invite. And if we are following the metaphor of this tree of intellectual property as a bundle of rights that has been flourishing over the last centuries, we also see that this tree remains healthy and very fruitful if we look at the real size of this tree, okay? Because one thing that probably I should have mentioned as when I introduced you the fundamental right in Article 17, paragraph 2, is that intellectual property is not absolute as a type of legal protection. So we do have, and using a metaphor I'm really I'm really affectionate to a tree that sometimes need to be pruned by Professor Séverine Dussolier when she talks about copyright. We really need to know everything about this tree. Also, its size and its height and its way to grow in a healthy manner. Now, the limitations we have of this tree, of this bundle of rights, are mainly of three natures. One is the limited duration of IP rights. You will study with your next speaker on trademarks and over the next days on designs and patent and copyright. Every IP branch has a defined limited temporal duration. So these rights are not eternal, are not perpetual. The limitation of IP rights also encompasses the limited scope of these rights. So not all the possible human activities are inside the scope of IP protection and therefore need an authorization or a license. And we have IP sector specific, some defined exceptions to these rights that we as a society felt it was necessary in order for society to thrive to have IP stepping back in some circumstances. But this is it. This is IP as a general concept, but what we are really interested in is IP rights in the European Union. So the tree magically became blue with a little bit of yellow because that's the jurisdiction we elected as the one we want to study most. I'm keeping an eye on the clock, but feel free to stop me if I'm going beyond my time. Now, I told you that I will give you 3 little pieces of information about IP in the European Union. One is the historical contextualization, and then we will be looking at full or partial harmonization processes. Now, I'm not a European Union law professor. I'm an intellectual property law professor, so I'm not telling you the history of the European Union, even though I find it extremely interesting. The history of the European Union IP story, IP legal framework is something, well, still very interesting, but it's more limited in its occasions. Many things have happened across our union and also in the formation of our union. You will see there 1957 as the Treaty of Rome, the start of the European Union as we know it today. But again, I'm just highlighting for you a few things that happened during these decades that relate directly with IP law. Now, why I start by the Treaty of Rome, the fact that the European Union really starting being a supranational legal system as such, because embedded in the European Union, there is the willingness of creating, establishing, and fostering, also supporting and making it stronger, the internal market. Now, the internal market, I think in the next slide, you will see it also better, is really what stands behind the harmonization of intellectual property in the EU. We do want goods and services and resources and people and capitals and investments to circulate freely across the member states. In intellectual property, especially for those of you passionate about competition law, is really something that goes together with these free movements that we are trying to keep as a flow and an energy flow for our economy. In the next slide, you will see why I'm stressing so much the internal market as our basis. But let's start seeing that already in the 90s, we had and we started having some very courageous harmonization processes that dealt with IP at EU level. So we had the very first copyright directive in 1991, that is the software directive, the computer programs directive. And we had several other copyright partial harmonization directives that looked into rather technical specific aspects of copyright law that at the time was fully nationally regulated in each member state. Now we had the rental directive, SAT-CAPEX directive, term, which was a very important one. The database, again, as I mentioned, software and databases somehow are very early on protagonists in the harmonization process of IP in Europe. And we had the design directive as well in the 90s, late 90s, 1998, something that you will be hearing in a very timely manner because the design law reform process has just reached a very important step just very short ago. Now, if we continue and we see how the European Union has been really developing in its own nature across the harmonization of IP, we see an important moment that was already mentioned to you today. That was 1994 with what we used to call the Office for Harmonization in the Internal Market. There you go. Internal market is really our basis. And today we know as EUIPO. But the real deal that I would like you to note down somehow is the fact that in the 2000s, and especially in the beautiful city that hosted me and adopted me, so in the Treaty of Lisbon, and probably this will make your memory a little bit relaxed because you can associate this to my own personal story. So with the Treaty of Lisbon, we had the laying down of the competencies of the European Union to really level up EU IP law as such. So we have two articles, and I don't want to sound too boring, this is the first session, but two important articles in the Treaty of the Functioning of the European Union that are Article 114 and 118. And these two really serve as an invite to the Union and a consensus across the member states to harmonize IP for the purpose of establishing and fostering our internal market, and also, very importantly, to come up with EU IP legal entitlements. So a new type, a new animal in the room, a new type of legal entitlement that was not just the harmonized national legal system over IP rights, but that were a new EU IP right. And this is something that we see very lively and very successfully in the European Union trademarks and in the community registered design. Now, as you see in the slides and the materials and the PowerPoints will be also made available to you, I think we have during the 2000s, because of this big impasse that the Treaty of Lisbon represented, we had the real start of harmonization and also of exploring around these EU IP entitlements as we are working with it right now. This harmonization, though, didn't have just a momentum and then stopped. This harmonization is pretty much ongoing and gathering still momentum really until very recently. I just mentioned the reform of the design regulation and directive just passed. And this is just exciting news for us because we see that much has been done, but we still have lots to modernize and also to harmonize from scratch, okay? So thinking of harmonization and something we can still be doing in the future. Let me introduce you the two different main categories that I suggest you keep very separate in your mind. The category of what we have fully harmonized in the European Union IP legal framework, or in the acquis, as we say, and those that are still building up their harmonization, meaning that what you see in the slide right now is fully administered at EU level and gives also entitlements that are enforceable throughout the Union under one only piece of legislation. I stress the fact that under the community registered designs and the EU trademarks, you have a lot of consolidated, not only legislation, but also case law to study. So everything that has been the practice of this EU IP legal entitlement is really a generous amount of learning materials for you. And I invite you, I encourage you to take this course, and aside from this course, to read more. You have really masterfully written not only case law, but also explanatory documents over the legislation that regulates these entitlements, and you have a very, very thought-provoking doctrine on them. We have plant varieties and geographical indications being a little bit the new kids in town, in the sense that it's true that they are not necessarily chronologically the most recent type of IP branches, but they are gathering importance and gathering attention, I would say, very recently. So we heard in the opening greetings by Mr. Di Carlo that there is also an economic relevance of these entitlements that only right now we are starting to solidly tap. And I think that's quite interesting for you as a numerous class you are, to find the IP branch that interests you during the course, but also to explore the newest, the overseen or neglected IP angles, and getting really an expertise on those. Because it's true that many businesses or many clients in law firms, they usually enter claiming, I want intellectual property, I want my intellectual property to be protected, having in mind mostly patents or trademarks or copyright. But it's true that we are the ones having to broaden the perspective, finding the right IP rights and IP tools, and maybe come up with a good strategy of an IP portfolio that includes some designs or some geographical indications or some plant varieties, even though they sound so unconventional or somehow not so popular. Now, the full harmonization of these, as I told you, gives you a generous amount of documents that you can learn from. What you can learn about, but also starting being a little bit creative in having suggestions or policy suggestions or your own opinions about how we should continue the process of creating EU IP law, is actually the threefold sector of copyright, patent, and trade secrets. Here we have a partial harmonization. That doesn't mean we have less information about them. In the case of copyright, again, my heart always beats copyright first. In the case of copyright, we have over 10 directives and 2 regulations that harmonize copyright in Europe. That's a lot of legislation, right? It's really a group of directives where you can spend hours and hours and days to read and try to understand to which degree we already harmonized copyright, patent, and trade secrets. Now, it's not a lack of input from the legislator. To some extent, it's also insufficient competence to fully harmonize, even though we have the possibility of having EU IP legal entitlements. But it's true that, for example, copyright law deals with also cultural issues on which the competence at EU level are dimmer. So that would be something that probably might require an adjustment in the treaties, or just creates an EU copyright entitlement ad hoc, being very accurate in its scope. And one thing that we are trying to do, because copyright again has been harmonized in a galloping way, also thanks to the digital technologies and the cross-border natures of those. But one thing that we are trying to proceed with is an harmonization that is sustainable. So when it comes to the constantly evolving harmonization of copyrights, but also when it comes to patents, with the big achievement last year, finally and officially, of the unitary effects of patents and the new experiences that you can really start reading about of the unitary effects and all what it comes to the tribunals that now are distributed in their own branches across the Union. And with the Trade Secret Directive in 2016, we are trying to build harmonization in a way that is coordinated, that is down to businesses and individuals, because they are ultimately the beneficiaries of IP rights. And we are trying to build harmonization consistently, systematic, in a way that is systematically sound. And this is something that takes time. That's why not everything in the European Union is fully harmonized when it comes to IP. Now, I have very few minutes left, and I did promise to collect questions if you guys have. I really need you to make your own sense of the information I started sharing with you, but reminding that we are talking about legal discipline when we talk about IP law that used to be fully and really in a sacred way, fully territorial. So every time we had to deal with an IP legal problem, we need to pin on the map the country where this legal problem arose, and we had to use those national legal rules to solve it. Now, harmonizing IP has two briefing moments for us. One is that those rules have been approximated and are being approximated ever more. And the second thing is that in some cases, European trademarks and community designs being the best examples, we don't have to pin on the map and to select a country and use their national laws, but we have 100% EU law to use and to solve problems. Second is that this process of harmonization, one briefing, and EU IP legal entitlement, second briefing, is really corresponding to the quest for common values and common objectives in the European Union and in its in our internal market. And third, last but not least, we need to understand that our internal market is already a digital single market. Every side, every sector, every little aspect of our economic activity, of our market dimension, had acquired a digital component. And that digital technology, that huge impact, I don't want to say things that are tried and repeated, and sometimes they just become void buzzwords. But that digital dimension really brought us to the cross-border. And the cross-border is the perfect moment to embrace an harmonized dimension where the rules can work, even in their limited scope or in some specific scenarios, they can really work European. And on this note, I think it's better for me to stop here. Yes, there is also the contact of our research center in case you're interested in IP and sustainability in the future. But I really thank you for your attention, and I hope that this overview, very general one, will help you navigating all about EU IP law over the next days. Thank you so much.
Thank you very much, Julia. If there are any questions for this, you can ask them in the chat. Is there anyone that has any specific questions to this presentation? Because we still have 10 minutes left till the next presentation. Yes. So someone asked, what are the main challenges the EU faces in fully harmonizing partial harmonization areas like copyright and patents?
Very good question. Sorry, Tom, can you still see my slides? Because I didn't stop sharing, but I think you did. Okay, great. Thank you so much.
I cannot see them.
Perfect. So you see me.
Yes, I see you. Yes.
Okay, nice. So let me see the chat. Someone was asking, yes, Clara, the main challenges on fully harmonizing all the IP branches. So for example, copyright and patents. That's, again, a question that would need to go again through the whole processes and through the whole attempts we have been doing in the European Union to harmonize. So these processes are usually slow because there is a lot of aspects to be taken into account. One of the aspects I refer to is the fact that harmonization means lawmaking. And lawmaking, in any case, needs to double check what are the competence grounds that I have to put together new IP entitlements, for example. And as I showed to you in a very direct way, the competencies could be there or are there because we have, for example, Article 118 of the Treaty on the Functioning of the European Union telling us we can have EU IP legal entitlements, meaning we can have a European Union copyright legal entitlement if we want it. Now, what are still the challenges? Why aren't we doing that? The aspects of IP that are more difficult to gather consensus on are notoriously or classically aspects that have to do with the balancing of IP as a private legal, I don't know, okay, perfect. As a private legal entitlement vis-a-vis the needs of society as a whole. So we very often in each IP branch refer to the balancing of interest and the balancing of rights as well in society that typically is represented by IP as a legal entitlement of exclusivity over an intangible resource versus the public interest. Now, in some aspects of copyright, of patent specifically, this balancing gets very tricky. And when it gets tricky, national member states tend to see a component of, for example, cultural policies or legal traditions or our own sense of justice. And when it comes to something that gets very national in its flavor, and the competence to come up with a new EU IP legal entitlement may be not strong enough, then you have a situation that gets stalled. In copyright, we've seen in patent law, we've seen that over the long negotiation for the UPC, and we had to go through a lot of decision making in order to have patent law really having their EU dimension. In copyright law, we've seen that not just as a difficulty negotiation, because we managed to get very many directives out, but every time we had a directive, we've seen that the private legal entitlement that the copyright gives with the public interest was something that always resized the directive to something a little bit smaller, a little bit more specific. And that's why the harmonization is still partial at the end. I see there are more questions, so I stop here. Tom, I can read.
Yes,
Yeah.
There's a second question. Would you comment the key international agreements related to IP in place? What are the key impacts, developments outside Europe that may impact our IP law and ambitions?
Oh, that's wonderful. Anna Maria, I think, posed this question. Thank you so much. So yeah, because I didn't want to overwhelm all the classroom with the first session, I actually intentionally omitted another important story that the EU IP law is also about, which is the harmonization of IP at an international level. So one thing that the European Union does is harmonizing its own IP law and coming up with the new EU IP legal entitlements. But first and foremost is respecting its own international legal obligations. And among those international legal obligations, we have very important IP law treaties. We have two major treaties, actually 2+1 major treaties of IP law worldwide, that are the Berne Convention, the Paris Convention. We could also mention the Rome Convention and the TRIPS agreements from the WTO. And over those international treaties, we've seen that the European Union has not only fulfilled, obviously, is abiding by those treaties, but is also taking a lot of inspiration to structure its own harmonization. So your question really gives me the opportunity to tell you, if something is not clear to you at EU IP law level, you can actually double check two things. One if that specific policy choice, that specific legal wording, for example, legislative wording, I mean, comes directly from the obligation to respect an international law treaty, or if it's not the case, if that's something that an international legislation or an international model law inspired, okay? So we have a certain amount of approximation of the law worldwide when it comes to IP that seems in some major aspect to be really much the global sense of IP. So the story of EUIP law, yes, is definitely also a story of a ever more globalized IP legal approach or IP legal regulation. This is something that some of you can also, or if we had a longer conversation, we could also look at something where we are missing some pieces, because the world is a beautifully diverse bundle of peoples. But it's also true that in some parts, IP gets also very technical. And when IP gets very technical, usually is where we are talking about exercise and exploitation of those rights. And those are scenarios where very often, not always, but very often, we are talking about trade and business and industry and technological progress. In all these dimensions of our globalized society already are pretty much transnational. So the fact that we have certain structure, certain approach or idea to IP law, again, I'm putting many things together and I'm ridiculously oversimplifying the discourse. But the fact that we understand each other when we talk about IP worldwide is something to cherish. Now, when it comes to the European Union way of IP lawmaking, of course, we have also our own features and our own best practices, let's say, when it comes to, for example, putting stakeholder dialogues meetings together and to listen to them and to get also influenced in our policy making when it comes to IP, because we want to open a little bit that discussion to the main stakeholders. That's something that in other countries, for example, we don't see. But yeah, let's not forget this, okay? You didn't see it in the slide, but the EU IP law is also a reflection, a little bit because it has to be so, and a little bit because it's an inspiration, but it's also a reflection of the international IP law legal frameworks that we have. Tom, I will never stop. Such a good question.
We have two more minutes left, but we have two more questions. So let's just the first one is, could you please tell me more about the sustainability aspect of the IP law? So in 2 minutes, I don't know if that's possible.
Let's see the other question what it is, and then I'll try to do
the other question is, in your opinion, what
mashup.
specific European policies either promote or impede cross-border collaboration and innovation among member states?
Okay, so we're talking about policies here. These are both questions that are too broad to be answered in 2 minutes. I'm so sorry to disappoint some of you at the very end. Let's start with the first. So on IP and sustainability, there is a lot to say. I run a center on this, so I just invite you to never to stop or shut down your curiosity in this line. I also have a personal interest in telling you this, because the more people that get interested in this duo of IP and sustainability, the better for me. We feel more like in a group. But definitely sustainability, as many other things. I was talking with my students, and I used the example of Formula One, not necessarily sustainability. It can be Formula One or your favorite sport or something. It's a great way to pluck an external element from IP law and use that element to navigate IP law. Sustainability does that in a brilliant way. But anything else that interests you outside the scope of this course can help you or might help you navigate IP in its intricacies, in its complexity. And sustainability really does that, covering all IP rights and making us understand the purpose of IP and the scope of IP and the litigation strategies of IP, in my opinion. And on the EU policy that brings together innovation and collaborations, mind, and I am finishing, mind the fact that innovation, collaborations, growth are important words in policymaking. When it comes to legislation, and when it comes especially to IP legislation, we try always to take those words and translate them into something more specific. And I think this is a good thing, because if we all agree that we want to collaborate more to put innovation together, because innovation is never a very lonely activity or an isolated person on top of a mountain doing it, we do want rules that don't just push us to innovate more, working more together. That would be more of an evocative rule rather than an enforceable one. In IP, even though probably you will like and dislike this, we always take these important policy goals, for example, fostering the EU growth and competitiveness, or putting together a collaborative framework of innovation, and we bring them into concrete ad hoc rules that, for example, in copyright, makes the role of researchers a role that is more protected in what they're doing, saying we don't want you to have chilling effects for copyright, because scientific research is a collaborative experience that produces something that is desirable in society. So
Julia?
yeah.
Sorry, I'm very, very sorry.
That's okay. I think I concluded and I gave a good example.
Yes,
so
yes.
for more, you will explore with the next speakers. Thank you so much, Tom.
Thank you very much again for your insightful presentation. Also, thank you for the participants for actually engaging and asking very good questions. But because we're very short in time, let us just go to the next presentation. So for that, we're going to talk about the overview of trademark protection in the EU. So we're going to have with us today Vera Sebastianova. Vera is a researcher and lecturer in trademark law at the Haneken School of Economics in Helsinki, Finland. She recently published a paper on trademarks in automated commerce and is now focusing on trademark parodies and tarnishment. Before academia, Vera worked as a consulting and in-house lawyer specializing in intellectual property, advising individual creators, tech startups, and large manufacturers. Through both her research and legal work, she aims to shape trademark law to balance business interests with broader societal values. So thank you, Vera, for being here today, and I give you the floor now.
Hello, everyone, and thank you, Tom, for this introduction. Again, hello, everyone. It's a great honor to be in front of you today, and let me share my screen. And could you please, Tom, confirm that you can see everything and hear me well?
I can see everything. I can hear you well. It's just not in presentation mode yet.
And now?
So now it is. Perfect.
Thank you. Okay, so I'll start. And I must make a short note that my presentation will be quite intense. I have to tell you everything about trademark law in 40 minutes, so I hope you will stay with me till the end. And my goal is to introduce, of course, you to this first IP domain that you are dealing with within this intensive program, so trademarks. When we're talking about trademarks, let's start straight to the point. We discuss legal protection of what we call a brand. Every day, when you're shopping or simply walking around the city, you encounter hundreds of brands for various goods and services, and most of them are registered trademarks. This is our topic today. You probably have been experiencing trademarks, well, very likely since birth. Think of Coca-Cola or Lego that even your parents might remember from their childhoods. Of course, trademarks are also names of automobiles and even colors, as in the case with Tiffany jewelry. You might know it even if you don't own it. You probably also have noticed the R letter used only for registered marks and the TM letters used for unregistered marks. But this familiarity of yours with different brands and even these R and TM symbols doesn't mean, however, that we people on average know what a trademark is and how complex the trademark law field. And I don't want to, threaten you with this complexity, but yes, it's complex, but it's fascinating at the same time. So let's try to build the foundation of this understanding today. I will today introduce you to the main trademark notions, then to the international system very briefly, and it has just been mentioned by Anna Maria, so I will talk about this. Then we will discuss trademarks in the EU generally, and then we will go to three specific blocks within the EU trademark system, meaning the subject matter of protection, what can be protected, scope of protection, what does it mean when you have protection, and limitations. And I will make some additional comments for your use regarding the current trends in trademark law, and maybe generally in business with respect to trademarks and names. And I will also discuss a little bit the intersection of trademarks and artificial intelligence, which is, by the way, often neglected when we have artificial intelligence in copyright and patents. Okay, so what is a trademark? The EU defines it in its regulation and directive as a sign, look here, as a sign, any sign, in particular words, designs, colors, shapes, and so on, provided that such a sign is capable of, first, distinguishing the goods and services of one undertaking from those of other undertakings, and second, capable of being represented on the register in a clear and precise manner. So trademarks exist in the form of any sign that helps distinguish products. With this respect, the function of a trademark to identify product's origin or source has been often underlined. For instance, the EU trademark regulation does it in the 11th recital. It talks about the indication of origin function of a trademark. And the Court of Justice of the European Union always refers to it as the essential function of trademarks. Let's remember that when we're talking about trademarks. To illustrate, even if the exact source of a chocolate, of this chocolate, different kinds of chocolate products is not known to you, you understand that this chocolate or these chocolate products are coming from somewhere under the control of one and same undertaking. Well, generally speaking, one source. Given all that, let's underline some keywords that we will operate with when talking about trademarks. So it's a domain of science. Then we're talking about distinguishing power of these signs to help people separate products. Next, products are mentioned, and we are always talking about specific goods and services for which trademarks are registered and used. Also, we're dealing with clarity and precision with respect to what a sign represents, how it looks like, and for what specific products it is used and registered. People have been mentioned. We deal with humans, consumers here, who perceive trademarks and might be confused about them. The notion of the average consumer is the one that we're also concerned with. Registration is mentioned, and indeed, we will discuss registration-based trademarks, regarding which countries harmonize their laws, as you have just heard. But please know that non-registered trademarks are also protected in many jurisdictions. We always talk about territory in which a trademark is used, registered, and protected. You've heard the word use many times already. Use and trademark, genuinely using it is key in keeping protection. And we often talk about fame, repute, or reputation. Trademarks like Coca-Cola that I mentioned are very famous. And in their regard, goods and services may not be so important, as you will learn. And in their regard, it is not about confusion, but something else. But this is a slide with keywords. Let's always remember about them. Why do we protect trademarks? So this, I continue my general comments before I dig deeper into the EU law. So why we're protecting them? In the United States, the dominant justification of trademark protection is the so-called search cost theory. Indeed, a trademark is a very convenient shortcut to products. For instance, it is faster to say Coca-Cola than to explain what kind of soft drink you desire. Hence, we have convenience and speed in shopping. In this setting, consumers' search costs decrease. It's faster to search for products. With this better decision-making, consumers come back to specific goods and services or avoid others. Therefore, producers become interested in maintaining the product quality so that consumers continue coming back. Producers also get interested in further investing in the promotions that create a certain image behind a trademark. I would refer to this publication. This theory is criticized, but since it has already had such a great influence on the trademark law, we need to know about it. In the European Union, search costs are not referred to directly, but the legislator and courts do care about consumer decision-making. You will see passages about informed consumers, informed choices of consumers, and in the end, about undistorted competition. All inter alia thanks to trademarks. That's why we protect them. One more important remark. We are mostly dealing with registered trademarks, as I have already mentioned. So let me introduce important notions here. As you will learn, if one attempts to obtain a trademark in the EU, they need to register a sign. Here, a trademark is granted to the first person to file an application, or as we say, the one with the earlier priority date. Remember also these notions. It is opposite to the United States, for instance, with its first-to-use system. Here we have requirements for registration. If third parties do not like the application, they may file an opposition in some cases. And if a new trademark gets registered, third parties may cancel it. When a trademark is registered and enforced, the right holder may stop other parties from using it by filing a lawsuit. It means that the right holder will enforce its right. Now we're talking not about the registration or cancellation domain, but about the enforcement and infringement domain. And it's here where limitations apply. We will talk about that. However, everything is interrelated. And if an alleged infringer files a cancellation counterclaim in a court case, we will again deal with the registration. But please remember about these two big domains, and always position yourself in one of these two domains so that you better understand what's going on. Now to the international system, very briefly. In 1883, as you have already heard, the Paris Convention was enacted, and then more than 100 years later, the TRIPS Agreement. And these agreements are very important in trademark law because they lay down the foundation, the minimum requirements for protection. There are other international instruments, for instance, these two ones, the Trademark Law Treaty, TLT, and Singapore Treaty on the Law of Trademarks. They laid down administrative norms. They harmonize some administrative norms, but there are much fewer signatories to these instruments. Also, you will have a separate lecture on the Madrid system, but there is also the so-called Madrid system, comprised of the Madrid Agreement and Protocol, that created a one-window, one-stop trademark registration procedure with respect to many jurisdictions. What's important to remember here, before even you start this lecture on the Madrid system, no international trademark covering many countries was created, no. But one administrative procedure for registering many trademarks in different jurisdictions was introduced. Finally, you will hear about the Nice and Vienna agreements and classifications. They are related to uniform classifications of goods and services and figurative elements or images. You will hear about them. So the EU and its member states are members of the TRIPS, except for EU to the Paris Convention. One can apply for a trademark in the EU or its separate member states through the Madrid system, and in the key trademark legal texts in the EU, this Nice classification is directly referred to. So it's time to go back to the EU system. What do we have here? We know that we have 27 states in the European Union, and each of them has its own trademark legislation. However, and this is our first level of the EU trademark system, all national laws on trademarks have been harmonized, meaning that the member states conformed many of their trademark norms to one set of rules, according to the EU Trademark Directive. And it is national IP authorities that handle national trademark procedures. At the same time, and this is our second level of protection that we will concentrate on during this intensive program, the EU itself has adopted its trademark regulation, that applies directly, no need for implementation. It applies directly, and it created a unitary trademark right, a regional right covering all countries in the Union. We're talking about an EU trademark in this context, EUTM, examined by the EUIPO. This is not a bundle of separate national trademark rights, but one right covering the whole Union. So this is the two-tier system in the EU, and as recital 8 of the EU regulation says, it should be left to each person seeking trademark protection to decide whether it will be a national trademark, an EU trademark, or both. And it is important to underline that many provisions of the directive and regulation are identical. It means that a coherent system has been created in the EU for the convenience of its people and businesses. Note that there is also the regional trademark in Benelux. We can put it on the first level, on the national level. And please be reminded that the international trademark registered through the Madrid system has to be separately examined in the EU and its member states if they are designated in this international registration. Okay, let's quickly look at some previous terms and norms. Please remember that the European Union, the EU trademark used to be called CTM, Community Trademark. Same with the EU Trademark Regulation, CTM regulation. You might have heard that the EUIPO was called the Office for Harmonization in the Internal Market. Also, the current regulation and directive, they are not the first ones. And on screen, you can see previous versions of these pieces of legislation. The EU trademark legislation has been developing for decades already. Why are we concerned? Why am I introducing this old stuff to you? It's all because of the CGEU. We know that the court interprets the EU law. However, for the EU IPO, and look at this line, for the EU IPO, which registers trademarks and performs other actions, the CGEU is the upper judicial instance in the case of challenging the office's decisions, first in the general court, and then, if accepted, in the Court of Justice on points of law. Here, we're talking about the registration cancellation stage that I referred to earlier. So I positioned myself here. It's the registration domain. As for interpretation, we have two situations. The CGEU serves here as the body that issues preliminary rulings, so here and here, about how the law shall be interpreted. And this concerns both the registration domain and the enforcement domain. For instance, some entity, and I will go back right now, like that, some entity does not agree with the, for instance, German IP office decision, challenges it in a German court, but the court has a question to the CGEU on the applicable trademark provision interpretation. So the registration domain, or some entity files a lawsuit to a German court because of a third party unlawful use of its trademark. And the national court again has a question on the interpretations to the CGEU. So both the directive and the regulation may be interpreted by the CGEU, and the court's interpretation of one of them shall be applied to identical provisions of the other. Remember about this when you read many influential CGEU judgments in the trademark law domain from earlier times, because many important judgments come from many years ago. And first, always start with understanding what concept, what norm is being interpreted, and find it in the applicable at that time provision, a legal text. Okay, and also remember I mentioned these old names of the EU IPO and old names of the EU trademark. In those old judgments, you will also see those old names, so don't be confused. Okay. Now it's time to focus on the European Union Trademark Regulation. That's why we are all here today and tomorrow. But a small comment, please always remember about the national level, which is harmonized through the directive. So now only regulation. And please remember that directive and regulation include many identical norms. I just want to highlight. Okay. First, before we go deeper into the regulation, remember also about other related documents. There are also EU trademark delegated regulation and implementing regulation. They're tied to the EU trademark regulation, and they contain many detailed rules on various procedures at the EU IPO. Next, there are EU IPO guidelines that reflect the office's trademark practice. This is not a legal act, but a handy tool. If you don't know where to start with when analyzing some trademark concept, go to the guidelines. It's a very well-structured text. And also, the EU IPO and national IP offices in the EU work together to develop common practices with respect to different issues. This is a great instrument to know how offices try to guarantee consistency in registrations. Topics like bad faith applications, for instance, can be found here. So keep in mind this text, these materials are available. Okay, moving to the main provision of the trademark regulation. According to the regulation, as I already mentioned, an EU trademark is a unitary right. It has a unitary character. Then a EU trademark is obtained through registration. It is obtained for 10 years initially, but can be prolonged for many numbers of indefinite numbers of 10-year periods, and then it can be registered in the name of any natural or legal person. So these are basic rules. Let's look again before we look again at the EU trademark regulations definition of a trademark. Let me show you how we will build our discussion now. There are three blocks that I will focus on. First, the subject matter of protection. As I mentioned, what is protected in accordance with the regulation. Then scope of protection, when it is protected, when a trademark is protected, what it entails, and limitations. Look, subject matter of protection is about registration, and scope and limitations are about that second domain that I mentioned. It's about enforcement. That just to remind you how these domains are seen when you read the registration. So the subject matter of protection. This is the definition of the trademark in accordance with the regulation that we started with. So it's a sign, any sign that has distinguishing power and can be represented on a register in a clear and precise manner. Since many provisions of the regulation discuss specific goods and services, there is already one more requirement for a sign to be a trademark. The list of products in the application shall also be clear and precise. Please remember that. Clear and precise sign, clear and precise list of goods and services for which it is registered. Other criteria for a sign to be appropriate, to be an appropriate subject matter of protection are listed not directly, but through the list of what cannot be a trademark, And this includes absolute grounds for refusal and relative grounds for refusal. As for absolute grounds, the EUIPO examines them on its own initiative, ex officio. No request from a third party is needed to do that. These grounds concern the nature of sign at issue. No opposition is involved, as I said, no third party's opposition is needed, though third parties are allowed to send observations, but they do not become parties to the proceeding. As for relative grounds, why relative? Because they are relative to someone else's rights, usually, well, typically to earlier rights. And the office addresses these grounds, checks these grounds only based on the opposition by an earlier party. Here, a third party is required to send an opposition. In some jurisdictions, by the way, these relative grounds are checked by the office ex officio, but not in the EUIPO. Let's quickly look at the absolute grounds first. There are many of them, but the key ones are the following. First is the contradiction to the trademark definition that we have just mentioned. Sign, distinguishing power, representation requirements. Here, some additional comments. You will hear that any type of sign can become a trademark. Look, word, figurative, shape, position signs can become trademarks. There is no limitation with this respect, though you will hear about some technological developments with respect to, for instance, textile trademarks or scent trademarks. You will discuss it later. Please keep in mind that word and figurative marks, meaning figurative, meaning containing images and or words, they are the most popular ones. Almost 99%. I would refer to the EUIPO statistics here. So words and logos are the most popular ones. However, if you want to register a concept, it's not clear and precise. It's not allowed. And to remind, please always remember about the clear and precise representation requirement. The graphic representation requirement has been abolished, but a clear and precise representation requirement with respect to any sign is in force. Yes. Next, let's go to the I would call it second group of absolute grounds for refusal. These include non-distinctive signs, descriptive and customary signs that they cannot become trademarks. If they, however, acquire distinctiveness, and this exclusion only applies here to this second group. So if they acquire distinctiveness through use, this ground can be overcome. So generally, there is no distinguishing power in non-distinctive signs like .com or simple triangle. There is no distinguishing power in descriptive signs like 24/7 for retail services. There is no distinguishing power in customary signs that have become customary in business, like a high voltage symbol. But if a sign like booking.com has been consistently used as a name for specific products and consumers associated with one source, it can become a trademark, as this one has done through acquired distinctiveness. Before I move to the next absolute ground, let me make one more interesting comment here. There is a simplified categorization of signs. It is not fixed in EU law, but it's actually fixed in one of the United States cases. They can be generally point or fanciful signs, which are the strongest ones. Kodak, for instance, it's an invented word. This group talks about invented words. Then arbitrary signs, these are typical words used in unusual settings, like Apple for computers. There are suggestive signs. They are not yet descriptives, but close to that. Sunny for lamps. Descriptive signs that we have just discussed. Think of sweet for chocolate. By default, it cannot become a trademark. And generic signs, tables for tables, not a trademark. I refer to these publications. As lawyers, because a trademark shall be able to distinguish products, we prefer the first two categories, invented and arbitrary words or signs. Marketing people and small companies might want to go with the third and fourth groups because it's easier to market them. But signs from the two upper groups are the strongest, as I said, in terms of easiness to register and scope of protection. Indeed, it is better to advise clients to pick a more unique name, though it might require some investments into familiarizing consumers with it. Remember about this clash. Coming back to absolute grounds. Next, the next ground, deceptive signs cannot be registered. Lacto-free for lactose, it's a lie. It deceives consumers, no registration. Signs contrary to public policy and morality, no, and cannot be overcome. Think of Bin Laden, or, well, it cannot be registered, obviously, and curve is a curse word in Romanian, so it's not registered. Then there is quite a difficult, complicated group of signs that cannot be registered, and acquired distinctiveness, again, doesn't apply here. It refers to shapes or other characteristics of goods, only goods are referred here, that result from the nature of goods, that are necessary to obtain a technical result, or that give substantial value to a product. Only applies to goods, as I said, no acquired distinctiveness. Think of a shape of banana for bananas. It relates to the nature of goods, so it cannot be registered. And there are also other grounds for refusal based on these absolute grounds. As I said, they concern the nature of signs. No opposition is required. No registration, except for this acquired distinctiveness rule for the second group of non-distinctive, descriptive, and customary signs. So we have covered this. Let's now cover relative grounds. As I said, relative means that these grounds concern other parties, earlier right holders, and opposition to applications become possible here. Please always keep in mind that there are three most widespread situations here in which a later trademark cannot be registered. They are double identity, likelihood of confusion, and trademarks with reputation. We refer to it as dilution by blurring, tarnishment, but also unfair advantages included, as I will explain. Okay, first, let's deal with double identity. No registration takes place if a later sign is identical to the earlier trademark and it is being filed for identical goods and services. When we're talking about earlier rights, we use priority dates to define who came first. So if an Apple sign for computers was filed 1 day ago, you won't succeed in registering the Apple sign for computers filed on the same territory today. Then the likelihood of confusion. There is no double identity here, since similarity is involved on the level of signs, products, or both. So a later sign will not be registered if it is identical or similar with the earlier trademark, and the goods and services for which it is applied for are also identical or similar with the earlier trademark's reputation. So similarity, identity, similarity, identity. But there is an additional element which is missing from the double identity situation. To prohibit registration, likelihood of confusion on the side of consumers must be proved. There is no such requirements, as I said, in the double identity situation. Okay, for instance, one Apple for computers will probably be refused because of the existence of the Apple sign for computers, which may cause consumer confusion regarding the source of computers. Remember the source origin discourse. And finally, we have the third major situation that concerns trademarks with reputation. Here, it's more complicated. So stay with me, please. Later application will not be registered if it is identical or similar to the earlier trademark with the reputation. So here reputation must be proved. As for products, a later sign will not be registered, in this case, irrespective of for what goods and products it is applied for. What matters is that to prohibit registration, it must be established that such a later sign would have a detrimental effect on the distinctive character of the trademark with reputation. It is called blurring, dilution by blurring, or detrimental effect on the reputation of this mark. It is called dilution by tarnishment, or it will take unfair advantage of the distinctive character or repute of the trademark with reputation. It is called free riding or parasitism. These all will apply unless a later trademark applicant proves due cause on its side. So a very complicated test. I just need to introduce you to it now. Examples. In this case, with famous magazine Marie Claire sign for bathing suits is considered as taken unfair advantage of the earlier mark, no registration. Famous Kappa mark for clothing is considered tarnished or degraded by Kappa for tobacco products. Here, the image of sports is degraded by the negative image of smoking. And to give a positive example for some diversity, dilution or weakened distinctive character of the famous spa mark for water was not found in the case with spa finders for travel agencies, just to show you what might happen in this respect. So we have these three major situations. With respect to them, you will encounter many questions, and let me just say the following, ask you the following. What does identity mean? What does similarity mean? What does likelihood of confusion mean? What does economic link under this concept mean? What is global assessment? What is oral, visual, conceptual similarity of signs? Who are average consumers? What is reputation? What is dilution, tarnishment, unfair advantage? What is the link with respect to reputed signs? What is due cause? So with these questions, no answers now, it's impossible. I just wanted to frame you for a more detailed discussion to follow. Okay, there are also other grounds, but in comparison to these three big cases, we can omit them for now. So we have just dealt with absolute grounds for refusal and absolute grounds, and relative grounds for refusal. I will not repeat now. But the important question next is what happens is if a wrong trademark has been registered despite the office's examination and third party's opposition, irrespective of whether it was based on the a wrong mark based on the absolute ground or a wrong mark based on the relative grounds. If it happens, the registration can be invalidated. The correct verb is invalidate. It means that the mark should have never been registered. Invalidation based on both absolute and relative grounds is possible. With respective absolute and relative grounds for refusal at the background, as well as additional ones. Look here. For instance, bad faith in filing a trademark application is also the absolute invalidation ground. As for the invalidation relative grounds, the procedure also includes provisions related, for example, to an earlier copyright. Please note that there is the notion of acquiescence, meaning that the earlier trademark holder loses the right for invalidation after 5 years of being aware of the later trademark registration. Again, just to frame you that so that you know that it exists. Note that the invalidation happens through the EUIPO or as a counterclaim in an infringement proceeding in court. Next question. What if something changes? What if a trademark was a good trademark, like in accordance with all absolute and relative grounds? Well, not in accordance, but well, it was registered. There was no absolute or relative ground applied. What if something changes with the trademark later after it has been registered? In this case, we will talk not about invalidation, but about revocation. Remember this verb. Here, the registration was legitimate first, but then something happened, so a trademark stops functioning as a trademark. The most frequent reason is non-use. It is because in case of non-use of a trademark for goods and services for which it has been registered, the connection in consumers' minds, in our minds, between the trademark and specific products for which it has been registered or used, it's lost. There is no trademark anymore, and others might want to take the name for their products. Other situations include when trademarks become common or generic, or when they are misleading. And as with invalidation, it is possible to revoke a trademark at the EUIPO or as a counterclaim. To repeat, invalidation means a trademark should have never been registered. Absolute and relative grounds apply here. The effect of invalidation applies to the past. Revocation means that there is no functioning trademark anymore, the effect of revoking is for the future. And both terms comprise the notion of canceling a trademark. So we are done now with the subject matter of protection. Let's move to the scope of protection quickly. The scope of protection, what is it? When a trademark is registered, I'll stop here. The right holder may prohibit third parties. And now look at the test. When I, as a right holder of a trademark registered at the EUIPO, may prohibit third parties from using my trademark. So it happens when there is no consent, when the trademark is used in trade in relation to goods and services, in our familiar situations. Double identity, likelihood of confusion, and reputed trademarks. So to repeat, first, the sign, someone's sign on the market, if it's identical with my trademark, and it is used for identical products for which my trademark is registered, this is double identity again, it will be an infringement. If these general conditions, which I will discuss in a second, are also satisfied, like not having a consent, being used in the course of trade for goods and services. Typical examples of double identity: it's counterfeiting, think of fake Puma sneakers, or it's illegal import of legitimate goods. Then likelihood of confusion. Here, the right holder may prohibit the use of a sign if the sign is similar or identical to its trademark and it's used for similar or identical products. And of course, a likelihood of confusion on the part of consumers must be proved. For instance, a party is selling chocolate under a very similar name, and the trademark is registered for chocolate. And finally, the use of a sign can be prohibited if it is identical or similar to the trademark that has reputation. My trademark is reputed, Coca-Cola. If it is used for any products, again, here similarity of goods and services is not important. And when blurring, tarnishment of unfair advantage is established, and this third party doesn't have any due cause, any fairness in using my sign, and there are such cases. So this is a typical trademark with reputation scenario. And for instance, when a famous brand is used for completely unrelated products. So this is the test. The law even gives some specific examples of formal uses of trademarks that can be prohibited by right holders, such as affixing a trademark to goods or selling them. You will not focus on infringement in this program, but you need to know about this topic, the scope, and also limitations that I will discuss. So let's now talk about this test in a little bit more detail so that you know what is involved. And why also I want to talk about this? Because one condition is not explicit, is not even stated in the regulation or directive. So to repeat, the right holder may prohibit 3 types of uses, this double identity, likelihood of confusion, and trademark with reputation scenarios when, if the following preconditions are satisfied. There is no consent on my right holder's side to use my mark. The third party is actively using my mark on the relevant territory where my mark is in force. This use takes place with respect to goods and services for which my trademark is registered, or if I'm Coca-Cola for any trademark, for any product. The use is happening in trade, commercial use is at issue. And now, here's the one condition that is not mentioned in the regulation. You cannot find it there. To apply the infringement test, one of the trademark functions must be negatively affected by this use. What do I mean? The mentioned functions, or the so-called function theory of trademarks, cannot be found, as I said, in the regulation or directive. It can be found in CGU case law. Remember, we started this lecture by saying that the essential function of trademarks is to signify product's origin. It answers the question, where does a specific product come from? With respect to famous signs, marks, you might have already thought that some other functions may be involved. Something else is protected. Something else is protected here. And the CGU said what? It's quality, investment, communication, advertisement, etc. What the CGU also did, except for introducing these functions which are not defined well and the list is not closed, what the CGU did is the following. The CGU put an equation between regular marks, non-reputed marks, and reputed marks. Let's see how this function theory is applied to our specific situations. For instance, in the double identity, here where it's happening, double identity has nothing to do with reputation, but If I want to apply double identity as a right holder, I must prove that one of the functions, even the investment functions, the function, which by law has never had anything to do with regular trademarks, I must prove that at least one function is affected. So this is now a part of the infringement test. In the likelihood of confusion, it's easier. Only the essential function of identifying origin is involved. And in the reputed trademark test, it's kind of also obvious because the functions have already been inputted into the test. Okay, and now I will conclude now because I see that I made too many comments, so I want to conclude in time. Okay, limitations. What tools does an alleged infringer have when a right holder files a lawsuit against it? First, it might interpret the infringement test, this one, in its favor. I will not concentrate on this now, but there are also specific limitations in the law in Article 14 of the regulation. First, I, as a third party, can still use my name and address if I'm a natural person, despite the fact that the name or address has been registered as a trademark by some party. Well, this is a rare situation. Then I can use non-distinctively and descriptively any signs, even if they have been registered as a trademark. For instance, I can still use booking, the word booking. Then I can refer to protected trademarks. If I want, for instance, to notify consumers that my good, as on this picture, is a spare part for Gillette razors, but this must be done in accordance with honest commercial practices. If I put on this package the word Gillette in large letters, it will stop being a reference. It will become a trademark, unfortunately. Well, that's how it works. There are also other provisions. Remember that comparative advertisement and trademark exhaustion, when you resell legally introduced products on the market, they are also a kind of limitations or exceptions, though there are internal limitations within them that allow right holders to actually pursue third parties in many situations. Okay, to repeat, we looked at the subject matter of protection at the registration domain, what can become a trademark. We looked at the scope of protection and limitation, and this is the enforcement or infringement domain. And let me make some final comments here. With this system in mind, I hope you will easier navigate what other lectures will offer you. But I would also like you to remember some broader trends, not on specific like registration issues. Please remember that the search cost theory that I introduced to you is actually a weak one, and it's highly debatable, and it's being criticized in the age of AI that I will discuss in a second. Then the role of research on consumer perceptions now is on the rise, because there are many achievements in this science of psychology and many axioms about how our mind works that have already been introduced to trademark law might be again challenged. There is depletion and congestion happening in trademark law. Many marks have already been registered. What is left for newcomers? This is another trend. This depletion and congestion are happening partly because of overclaiming by many companies. When I, as a trademark applicant, apply for a trademark, I might put many products for which I register my trademarks, even if I don't want to use my trademark for those products. This is what the system allows us to do. But because of this overclaiming, again, no signs are left for newcomers. Then trademark trolls and big companies which act as bullies, they also make the system much more complicated and complex and negative for newcomers, for small businesses. Trademark trolls register many trademarks and then threaten small businesses. Big companies threaten small businesses with their long trademark registrations. But trademarks are significant for SMEs. I refer to the EUIPO and EPO report. As for AI, and this is my one of my last. Yeah, I'm finishing now.
Left.
Yeah, 1 minute left. Just think about how trademarks are also an important topic in the age of AI. It is a new administrative tool, but also it changes our new shopping architecture. If you're interested in this subject of AI, remember that in trademark law you can also discuss in trademark law you can also discuss AI. Think about different types of confusion that exist. Think of how we think about consumers, fools or rationals. Think about how we even write the word trademark. In EU, we write it in 2 words. But please always apply critical thinking when dealing with trademarks. And I wish you good luck. And if you have any questions, please, you can send me email at any moment. Thank you.
Thank you so much. Thank you very much for that interesting overview on trademark protection in the European Union. Now let us continue in the program. We already have the next speaker coming up, Dionysios Daousis. I'm so sorry if I butchered your name. And his session on trademark application and examination proceedings. So he has a background in regulatory and customer-focused roles as he worked in compliance and customer success departments in the gaming and cryptocurrency industries in Gibraltar before joining the EUIPO. He has been working in the business operations department since December 2022, and he's focused on absolute grounds and trademark examination. So without further ado, I will give you the floor, and you can present your topic.
Thank you. Thank you so much for the introduction. It's great to be part of this IP intensive program. Good morning, participants. Thank you so much for being here today. I'm going to now share the presentation. Well visible?
Yes, very good.
Okay,
thank you.
Lovely. Thank you so much. Good morning again. So in the next 35 minutes, more or less, you will be given information about the trademark applications and the examination proceedings. So our agenda, EU trademarks, an introduction, the process of filing, the examination of formalities, and the examination of classification. When this session is over, the presentation, there will be also some time for questions and answers. So if there are any questions, please be patient. At the end of the presentation, we will talk. So let's see. What are trademarks? Trademarks are signs that are used in trade to identify goods and services. They are brand identifiers. You might think, is this important? Yes, it is absolutely important in trade because if yourself and me, we offer the same products or the same services, we need customers to know what the source is so that they can actually repeat the process. They can actually come back to us and buy again our products or services. Trademarks can be many different things. They can be a color, they can be a patent, a word, a figure, either standing on its own or combined with some word element. We will talk about this in a bit. Right. As you already know, I am part of the operations department here in the EUIPO, which is the European Union Intellectual Property Office based in Alicante, Spain. Here we receive applications from all over the world from entities who wish for their trademark to be registered and officially recognized throughout the European Union. The EUIPO plays a very important role in the protection of intellectual property, but does not stand on its own. It is part of a wider system, which includes the World Intellectual Property Office in Switzerland, national offices which stand in different countries throughout the world, and as well regional offices like the one of Benelux. So quite a wide system. Now, how does one apply for a European trademark? Probably you have already done some digging and you know how it is being done. Let's see this together. How do we file? Well, nowadays, there are different ways for someone to actually present their application. It can be done by e-filing, which means that the applicant will use the user area of the website of the EUIPO. If this happens under certain conditions that we will see in a second, the application could be a fast track, which is an accelerated process that we offer to the applicants, or they can decide to do it traditionally via post or via a courier. So, how can one application be actually a fast track? What are the main conditions for that? Well, first and foremost, we need to have an application for an individual mark where the goods and services list will have been prepared according to the harmonized database. We need a prompt payment within a month. We cannot have search requests, and there should be no errors, no deficiencies in the file. Why? Because if this happens, then the examiner needs to get back to the applicant and request for the deficiencies to be fixed. If this happens, the fast-track status is lost. So, the examination period. What happens? Receipt of the application, an examination period that can be shorter or longer, as already explained. And then we have the publication of the application as soon as the examination period is over. When an application is published, a 3-month period starts. This is called the opposition period. During this period of time, other entities who already hold trademarks can stand up and say that, I'm really sorry, but this new application that you have published looks very much like mine. Your trademark looks like mine, and this could create confusion within the consumers. So in order to avoid that, an opposition process starts. If this does not happen, when the 3-month period is over, a registration takes place and a certificate is issued. The mark will be valid for 10 years, and the life cycle of the mark starts, during which we can see some changes. Like, for example, after the 10-year period is over, we can renew the mark, but more changes might happen. So, for example, there might be a transfer, and a holder might decide to transfer the trademark to another entity. We might have cancellations, like, for example, we might have the trademark being revoked because actually it has not been used for 5 years in the European Union without a valid reason, and in this case, it's been revoked. Or, for example, it might be declared invalid if we registered a trademark which was breaking some of the main rules. For example, a deceptive trademark should not have been registered, and if we find out that indeed it was deceptive, then we will have an invalidity. So many different changes might happen during the life cycle. The owner of the trademark might decide as well to renew after 10 years and repeat after 10 years, etc. So when we're talking about formalities, we are talking about a set of formal requirements which are dictated by the European Union trademark regulation, and each and every application needs to comply. So it is part of the examination process to check whether the application actually complies with the requirements. When an application comes in, it is given a filing date, but for this to happen, fees need to be paid. Two languages need to be chosen by the applicant for the communication, and they must be visible in the file. The persons, both the applicant and the representatives, if needed, need to be visible in the file, which needs to be signed by an individual. Details like the kind of mark, the type of mark, and the mark itself, its representation, also need to be visible in the file. Previous intellectual property rights will also be checked as part of the formalities examinations and more. So, for a file to be given a filing date, what are the 5 conditions that need to be fulfilled? We need to have a proper request for an EUTM. The form needs to be properly filled in. The applicant needs to be identified. The mark itself needs to be visible in the file. The list of the goods and services that will be protected by the mark needs to be also visible in the file. And there are also fees that need to be paid. With regards to fees, very important, because if there is no pay, there will be no play. We will not move forward with the examination of the formalities if the relevant fees have not been paid by the applicant. How much money are we talking about? The basic fee for an individual mark is 1,000 euros, which will go down to 850 euros if the applicant has used the user area in the website. Then, when we're talking about collective or certification marks, the fees change, they go up. The basic fee is 1,800 euros, which will go down to 1,500 for refiling. And another point that is very important and related to classification, we will see it in a bit, classes. So a mark might protect, it might cover the goods or the services that belong only to one class, but maybe not. It might be protecting goods or services belonging to different classes. It might as well be protecting both goods and services. So we have more than one classes in this case. The second class, the fee for the second class is 50 euros. For the third, fourth, etc. classes, the fee goes up to 150 for each one of them. Now, languages. The applicant needs to choose 2 languages. The first language in the file can be any official language of the European Union, Maltese, Estonian, Italian. But then the second language definitely needs to be one of the 5 languages of the office. The 5 languages of the office are Spanish, Italian, French, German, and English. These will be used as well. The languages will be used for all the proceedings. And the applicant needs to decide which one of them they want for the communication. Let's say, for example, in which languages will the letters that they will receive be written. But under special circumstances, we might as well need to use the other language for communication. When we examine the people who participate in this process, the applicant and their representatives. So the applicants who come from outside of the European Economic Area, which includes the European Union, Liechtenstein, Iceland, and Norway, will have to appoint a valid representative based in the European Economic Area. Apart from that, the legal form of the applicant needs to be visible in the file. We need to know their address. And as already mentioned, the application will need to be signed by an individual. So, quick question. What kind of European Union trademarks exist? Maybe you can post in the chat if you know. Let's wait for a second. Okay, let's see. What are the kinds? Well, we actually have 3 different kinds of trademarks. We got the individual ones, the collective, and the certification ones. What are the differences? Individual trademarks belong to entities, individual people or businesses that are the only owner of the mark. They are the only ones who have the right to use the trademark throughout the European Union to protect the goods and services that they offer. When it comes to the collective marks, this belongs to collectives, like, for example, associations, and all the members of the association have the right to use the mark for the same reason like the individual mark is being used. And then we got the certification marks, which are quite special. Why? Because here we have an independent body which sets up some standards with regards to goods or services. That could be standards regarding the production process, regarding the materials used, regarding the geographical origin. This independent body sets the standards, and then different entities actually are being certified by the independent body that they do offer goods and services of the requested standards. These third parties are the ones who will use the certification mark for their goods and services, not the independent body, which is the owner of the mark, but is not really using it. So, different types of marks. Many different things can be a trademark. A single word can be a trademark. A single figure can be a trademark. This one could also be combined with some word element. A shape can be a trademark. Like, for example, you walk into a store and you find a beautiful perfume in a special bottle. This bottle is the trademark of the company that created the perfume. A color is a trademark, even a sound. Let's hear. This is a trademark as well. A position trademark. Here, what we care about is the special placement of the logo on the product. A pattern, even a motion mark. Here we care about this movement that happens. This mark is actually moving, and this exactly is a brand. Multimedia, I'm going to show you one that 99.9% of you already know. This is a multimedia mark, and as well, a hologram. Now, a hologram is actually a mark that will change. Its vision changes depending on the angle which we look at it from. Right. So there are different TM types which are accepted and registered. Which one do you think that the EUIPO has received the highest number of EUTM applications for? Probably you already have an idea. You have a guess? Let's see. By August 2024, by far, number one applications were the ones for the word marks. 56.83% of the applications were for word marks, followed by the figurative ones, which with quite a lower percentage, 42.57% of the applications were for figurative ones. And then for the rest of the categories, the numbers are quite low as compared to number 1 and 2. Right. As already mentioned, previous intellectual property rights can be part of an application, so they can be claimed by the applicant. So, for example, when it comes to priority, the applicant claims the filing date of an earlier trademark application, and the priority date will be considered as the filing date of the European Union trademark. So I already applied for a trademark on a national level. I present with my EUTM application this priority claim, and I request for this date that the national trademark was presented to be the date accepted in the inter partes proceedings. So if we have an opposition, then the date that will be accepted officially for this trademark will be the one of the priority. Then with seniority, we claim the rights of earlier national trademark proprietors to continue to exist even when these trademarks have lapsed. Like, for example, I might have already a national trademark in France, let's say. If I claim the seniority with my EUTM application, I can stop paying. I can just not renew the trademark in France, and the rights that I have continue to exist through my EUTM. So, so far we have discussed the formalities checks that take place in the very beginning as soon as we receive an application here in the EUIPO. Now let's talk about classification, which is also a very important part of the examination proceedings. With classification, we mean that products and services will need to be put in the right category. We have in total 45 classes, which correspond the 34 to products, goods, and the rest of them to services. The EUTM needs to be limited to specific goods and services. We anyway have thousands and thousands of different products and services that one can apply for, but still, the application will either need to provide goods and services identical to the ones that can be found in the database or similar to them. Everything is based on the NIST classification system, which, together with the relevant articles that are provided in the EUTMR, give us a clear framework for both the applicants and us examiners to classify without errors in the file. This means that the applicant might present a file which is flawless, but if this doesn't happen, the examiner will get back to the applicant and request for the errors in classification to be fixed. Now, a very big ally in this process is the IT tool that we use in order to do this classification. I will show you that to you in a bit, and indeed it's very helpful for us to do the process. What needs to happen? We need to have clear and precise identification of the goods and services as per the relevant article of the EUTMR. The scope of protection needs to be well understood, not only by the applicant and the examiner who will do the file check, but in the future as well by the other examiners, other people who will refer themselves to the file, and they will also need to understand what the scope of the protection is. Tennis classification is always the basis for this process, and the classification will be done according to the function or purpose of the goods and the services. The tool that we use in order to do the classification is called TM class. Now, this tool incorporates various lists. that are being updated and maintained by different entities, by different organizations around the world. We're talking about 85,000 terms in English that are also translated into the rest of the European Union languages based on the NACE principles. And then in TM class, we have incorporation of the alpha, for example, and the MGS, which is the Madrid system lists. These are maintained and updated by the World Intellectual Property Office. The harmonized database, which is being maintained and updated by the national offices in the EUIPO, and as well the ID list, which belongs to the USA, the American Office of Patents and Trademarks. This actually gives the opportunity to have harmonization. This is the main goal here, to have a harmonized system so that entities from different countries can easily apply both for a European Union trademark today, in a few months maybe for a trademark in the United States, or then for an international trademark with EUIPO. So the idea is for the ones who offer, the businesses that offer goods and services, to be able to easily present trademarks, create the trademarks, and have their goods and services protected around the world, if possible. Right, so the TM class tool. This is what you see when you open the TM class. Now, as you will see here, we can choose the language that we want to do the checks. We can paste a term, be it a good or a service, in the search form. We can either choose the class that we want to check, or we might as well want to see different goods or services, whether they belong to different classes. So we leave this free, empty, and we search. Important databases that we have in the tool are the NIST class headings, the general remarks and explanatory notes, and the rejection list. Now, when it comes to the class headings, they provide us with a general description of the different categories, what they would include. The harmonized rejection list provides us with a list of terms that we should never accept, and that's very helpful for everybody for obvious reasons. And then its general remarks and explanatory notes dig further into each and every class and provides us with relevant information. Let's see. Right. For example, class 37 explanatory note. Here I can see what the class includes. For example, 37, mainly services in the field of construction, etc. What does it include in particular? A list of the services that it includes and what it does not include in particular. So when the examiner will sit down to check a list in an application, they will check whether the services, for example, that the applicant wants to include in class 37 can actually be part of class 37. Imagine, let's say for class 39, transportation, and instead of putting transportation in class 39, it's been put in class 41. In this case, the examiner will send a letter to the applicant explaining that there is an error which needs to be fixed. And obviously the applicant, together with the representative, if they have one, will sit down to discuss and get back to us to say whether they agree or they do not agree, whether they wish to remove the term because it is not clear enough to them. Different scenarios. Now, with regards to the principle of classification, the principle of classification is that the original scope of classification can be limited at any time, but it can never be extended. The owner of the owner as well, not only the applicant, but the owner later of a trademark, has the right to send a letter to the EUIPO and request for a limitation of the goods and services in the list. No problem at all. It can happen. What cannot happen is for the scope of protection to be extended. This is something that we cannot do. And actually, one of the errors that happen sometimes is for an extension of scope to be requested. And obviously, the relevant communication then needs to take place. We get back to the applicant and we explain, or the owner as well, and we explain that an extension of scope would not be possible. Punctuation is very much important, and actually it's quite interesting that the punctuation changes depending on the language. It's like, for example, in English, we use comma to separate different products to separate the different services in service classes. In Greek, for example, we use the upper dot to do the same. But in anyway, punctuation is very much important, and we need to fix it if it's not properly done. So we need semicolons. We sometimes see semicolons versus commas. As already said, the goods need to be separated by a comma in service classes so that we have, for example, legal services for X, Z, Y cases. That should be separated by comma, or as well if we offer services for certain goods. If we have a restriction, it is important to use correct punctuation as well. So we need to restrict properly. We need to know exactly how smaller, narrower the list will be. A very important point are the unclear and imprecise terms, because sometimes, and it is absolutely normal, we receive applications from all over the world from entities that do offer definitely different kinds of goods and services as compared to others. And many of them have no exposure to intellectual property. It might be their very first application. In this case, it is quite normal that someone might get confused, that someone might have wanted to explain what they do, and they have done it in a way that is not actually clear to us. In this case, the examiner gets back and requests for the imprecise term to be clarified. Imprecise terms can never be part of the application. Sometimes there are references within a class to other classes, which is also not accepted. And when it comes to the geographical indication, a specific wording needs to be used. If I offer a product that comes from a specific region, it is pre-decided how exactly this should be written in the file. In case that it is not done properly, then we have a deficiency, and we get back to the applicant to request for the deficiency to be fixed. So what we have done so far, we have discussed we have shared information that has to do with the European Union trademarks, what they are. We have discussed the role of the EUIPO in protecting intellectual property and being part of a wider system of intellectual property offices. We have discussed the formalities checks, what a file needs to comply with in order for it to be considered properly filled in and for it to move forward. And obviously, we have also discussed classification, which is the second phase of the checks that are being done. And this one has to do with the goods and services and how they're classified into different categories, which are called classes. So this is it more or less, at least for now. If there are any questions from your side, I would be happy to discuss.
Thank you so much, Dionysi, for actually your very accurate and on-time presentation. So have a bit of time because our break will be at 11:40. Of course, if we don't have any questions, we can have it a bit earlier. So please now in the chat, if you have any questions from your side that we can address to Dionysis. Maybe you can stop sharing also your screen so they can really see you and reply any questions. So we have one question actually in the chat. Trademark regulation embraces a wide definition of a sign that may be registered as a trademark, including, for example, scents and tastes, international agreements. Can you please comment registrability and attempts to register these type of signs in Europe?
Please be so kind and repeat the question because I didn't hear you very well.
Yes, so that the trademark regulation embraces a wide definition of a sign that may be registered as a trademark, for example, including also scents and tastes, flavors. So can you please comment if there is registrability attempts to register this type of signs in Europe? And I suppose in our office, maybe.
That's a great question with regards to scents and tastes. I would need to dig a bit further, and I would be more than happy to get back to you if you leave me
Hi,
your.
Irena. Good morning.
Hello?
So yeah, I don't know, there was someone talking, but it's fine. Please, Dionysi, you can continue.
Yes, I was going to say, kindly let me dig a bit further, and if you leave us your contact details, I will get back to you and give you information about that.
Okay, thank you so
Definitely,
much.
in our department, it is something that we do not check. So I would need to talk to the relevant people and get back to you.
So thank you so much for that. Next question, could you please explain again what is a certification trademark?
The certification trademark is owned by an independent body, which creates some standards for other entities to comply with, to reach. The entities, the businesses that offer goods and services that actually reach the standards that the independent body has created have the right to use the certification mark. The certification mark is not used by the independent body itself, but by the businesses, the entities that actually have reached and have been given permission to use the mark on their goods and services.
Okay, perfect. Thank you so much. Do parties who object to a registration need to pay fees for this?
Yes, for the opposition, they would need to pay fees. Yes, indeed. The opposition process is a different one.
Exactly. So next question is what is the focus approach to the trademark regulations inside in the interlingual setting? I'm not sure I understand.
The interlingual, excuse me?
Setting.
Maybe the person who asked wants to speak up so that we can have a conversation.
That we can give the floor to you in order to clarify a bit your question. And I think we have also a raised hand. If I'm not mistaken, this is because you want to ask something from Trinity College, Dublin, Valentina.
Yes, can you hear me?
Yes, Valentina, hello.
There you go. If you can switch on your camera, please.
Yes.
Yes, thank you.
No worries. You mentioned there were two paths one can argue when it comes to the infringement of a patent. So you can either argue based on your priority or like the priority argument. So like when your trademark was registered in the EUIPO offices, or you can also argue for the seniority of your trademark. So that's when your trademark was registered in your national IP offices. I was wondering what happens when there's a clash between them both. So when a trademark has been registered in the EU IPO offices, despite a national trademark being registered for a different company somewhere else, is that possible? Does that happen?
There would be a dispute as part of the opposition process. Unfortunately, I do not do oppositions myself. So when it comes to oppositions, I'm not the number one person who could provide information about. But any knowledge I have about the issue, I'm very happy to share with you. So it would be part of the oppositions, and actually the different parties would use prior intellectual property rights in order to make their position stronger in the opposition process.
And just if I can also jump in to just briefly say that we will have an opposition proceedings session in the afternoon by our colleague Kieran Hennigan. So maybe you can redirect the question to Kieran later on, Valentina.
Okay, thank you.
Thanks, Valentina.
Thank you very much. And I see we have another question as well. Can we explain more the part about trademarks of colors? Is the hex of color trademarked? So you can please give some more explanation on that.
Different colors can be claimed to be the trademark of a certain entity. So it might be a color on its own, a special tone of a color, but as well it can be a combination of these. And actually, it would be great. It's something that I haven't done myself. I have never done checks on colors, but it sounds really interesting because of the whole process of presenting, and then if there is an objection from our side, how it would be the exchange of letters. It would be actually very interesting. I understand that the amount of applications when it comes to colors as well is quite low. So there is not so much exposure. But still, yes, definitely, as said, with regards to sounds, holograms, etc., colors are also part of the process. One can actually claim a color to be their brand identifier within the EU.
Thank you, Dionysi. So next question is, what is your opinion on larger corporations overclaiming on registration through many classes and their non-use of this?
As mentioned, if there is no use of a trademark for a certain period of time, there can be a dispute. Yeah. Then talking about the big corporate companies, no, probably they register for many different products and services, so some use there will be. But yeah, what exactly is the question? Whether it's ethical or from what point of view would you like to discuss it? Having a trademark for different goods and services and using it for some.
I mean, there is no, let me see if someone replies. Maybe, Ruben, I see you switched on your camera. Maybe you want to take the floor? Let's unmute you so you can please clarify your question now.
Yes, it's more from an ethical point of view, firstly, and in my trademark class at Queen Mary, I think there was this case where they're still debating it, and I just wanted your opinion on it, maybe, where if you overclaimed, there was a possibility that they were going to decide for a full revocation in terms of bad faith. I just wanted to know your opinion on it. I don't know if we could.
But if you want to discuss it from an ethical point of view, at the end of the day, if since they applied for a trademark, they went through the process and the trademark got registered, they have the right to use it as per their own strategy. Yeah. At the end of the day, as said, if it is not used at all, there can be a dispute. Whether they will use it for each and every of the products and services they offer, it really depends on them. I do not think this is a personal opinion right now. Disclaimer: I'm not representing on this the EUIPO. My personal opinion here is that they have the right to use the trademark as they wish for the period of time that it has been registered, and then obviously, if there's no use, there will be a dispute. After 10 years, when they renew, they might as well decide to make changes, or during the life cycle, because they might as well see that finally we do not really use this trademark for this category. We want to create a new one to cover this category of goods or services. But I think it's their own right to do so. Many thanks for the question, Ruben.
Thank you very much, Ruben. I see another question as well. So are the trademarks and copyright symbol protected as well, or could a private party use these logos for deceiving purposes?
For deceiving purposes?
The actual, the sign of the R, I suppose, in the circle and the C in the circle.
Oh, yeah, definitely.
Daniel, this is what you want to say?
If this is the question, definitely there are cases in history where a trademark has that entities, let's say, but actually we're talking about fraudsters here, have tried to use trademarks. And as well, it's not part of this conversation. It's a very interesting conversation, though. There can be fraud in trademarks as well. So yeah, it is a possibility. And definitely here we got the observatory as well in the EUIPO that one of its functions is to actually keep an eye on the market and see whether we have fraud and in which cases, and to support the fight against it.
Perfect. Thank you so much, Dionysi, and thank you so much, Daniel, for your question. I don't see any other question, I must say. There were many, Dionysi. Until now, you had the highest rate of questions, I must say.
Thank you, everyone.
So I think that this is a good thing. That means that they were paying attention. So
Great.
I don't see another question. No, there is one, and the long one. So, do you believe that one reason for wordmark applications to be more than figurative mark applications, in addition to the inherent reason related to the nature of wordmarks, is that figurative marks containing words do not adequately protect the words themselves? Should those who have both a wordmark and a figurative mark, including words, prioritize applying for the wordmark first?
I would not say that entities should prioritize word marks over figurative marks. I do not see a reason for that. It is true that the figurative mark stands out in the sense that it combines the word with a figure, which can be something quite special. And at the end of the day, we want trademarks to be distinctive. It's one of the main points that we look at. And definitely for a word mark, it's more difficult, let's say, to be distinctive. But still, I believe that one of the main reasons for word marks being so popular is the fact that there are also, between the thousands and thousands, the millions of companies that apply for trademarks around the world, there are many companies that are quite new to the intellectual property field. And for them, imagine, for example, a 28-year-old starting their first business. Let's say they want to create a mark. Most probably the first thought is to create something simple and something that people will remember. No, but something simple. Like, for example, two friends, they get together, they create a company, and they say, okay, half your surname, half mine, we put them together. That's the mark, the word mark of our company. My understanding is that figurative marks are harder work in the sense that you really need to decide what figure represents you. And this is not as easy as with words that we're more used to use for our expression. It's part of it's our language, so it's easier for us to express ourselves using a word as compared to a figure in adult life.
We have two more questions, but I think we have time only for one of them. So I'll go to the first one. Hello, I was wondering if whoever addresses the requests in the EUIPO offices is actually chosen based on the nature of the trademark analyzed, for example, to determine if a product name is confusing or not for hypothetical customers, and if you rely on specialized figures like engineers or actual divisions.
Okay, I hope I got the question properly. The answer here would be that with regards to the examination, it is done by examiners who are educated here how to do the examination and how to prepare the relevant communication. So we do not rely on external support. The examination is done within the office, within the boundaries of the office, by people who work for the office. I hope I've covered you with the answer to the question. If not, please.
Yeah, I
explain.
think I suppose that this say if they will have specific also colleagues to test the trademarks of specific fields. This is what I understand. It's actually chosen based on the nature of the trademark. If a program is confusing and for a hypothetical customer, you rely on specialized figure like engineer or actual divisions. This is what I think they want.
Imagine an engineering company, for example, will create a trademark which could involve, let's say, a figurative part and a word part. That would be checked by the colleagues here in the operations department, and colleagues here have the needed knowledge in order to get back to the applicant, an engineer in this case, and explain whether there is an issue with the trademark, whether the figurative part is not figurative enough, whether the word part is descriptive, etc., etc.
Thank you so much, Dionysi. And actually, even though we have one more question, I would suggest to stop the session here because we are only just 2 minutes before the break. And for any further questions, please do not hesitate also to contact us and let us know about the specific speaker and session so we can address them to them. And if they wish, they can reply to you directly with any specific clarification, etc. So
thank you very much. Thank you, everybody.
Yes, thank you so much, Dionysi, again for
Take
your
care.
time with us and for your presentation. And now it's time to have a very short break, but really very short. That means at 11:45 we start with the next session, actually about the international registration of trademarks from our colleagues from the World Intellectual Property Organization, from EUIPO. So please, I would suggest not to go out from the meeting, but you can just, all of you have your camera switched off, but keep them as such, both your microphones, and we resume like in 6 minutes sharp at 11:45. Thank you. So that was fast, I think, as a break, but hopefully you had a bit of time to, drink a bit of water, coffee, to go maybe to the bathroom, or just to abandon the course because it's too intensive maybe for you. So now we're moving to the next presentation, and with an informative session on the Madrid system for international registration of trademarks. So I would like to welcome our first speaker, Aurea Plana. I hope I pronounced your name correctly. Aurea is a qualified Spanish lawyer with 15 years of professional practice in the field of intellectual property, mainly the Madrid Register for International Trademarks at the World Intellectual Property Organization, EUIPO. And if I'm mistaken, Area, you're going to have this presentation jointly with another colleague of yours?
I think he will follow from mine, yes.
Okay, so I will just say the name already and a bit of introduction. So then the additional speaker together with Aurea is, I hope I will pronounce the name correctly, Hongbing Chen. And Hongbing has been managing operations for international trademark registration under the Madrid system since January 2019, and also contributes to EUIPO task forces on artificial intelligence, digital transformation, and customer experience. He joined EUIPO in 2015 as director of the EUIPO office in China after a career in China's diplomatic service and involvement in various UN projects, including serving on the UN Secretary General's multi-stakeholder advisory group on internet governance. So I would like, firstly, thank you very much, both of you, for participating in this course and providing your presentation on the Madrid system. And I would like to give the floor firstly to Aurea.
Yeah, thank you so much. It's a pleasure to be here with you. You are so many connected. I will share quickly my presentation for today. So,
yes, if you can put it in slide mode.
yes,
perfect. Thank you.
Okay, it was just a bit slow, sorry. So as announced today, I will be introducing you to the Madrid system for the international registration of trademarks. So we will see what's the Madrid system, what is the geographical scope, in which countries the Madrid system has effect. We'll see a bit how it works, the basic features, the main idea about how it works. I will briefly talk about its legal framework and the recent developments, and then I will just show you some statistics about the numbers, how we are doing, and how you can keep update with the Madrid system. So what is the Madrid system? It's called the International Trademark Registry, and it's because it has a wide coverage over the world, and it's where applicant holders of trademarks can go and register their mark, what we say, in so many countries that it's almost international. We keep this registry centralized. So when it's interesting to use the Madrid system. So as you know, when someone has a trademark, it's dealing mainly in his region. You start in the market, you know, something that it's close to, you're familiar. And at some point you are doing well, that trademark applicant or holder is doing well, that trademark owner is doing well and wants to expand his business, and wants to expand beyond the borders of his country, of his region, and starts to think, how is the best way I can do that? So at that point, he will have several options. He can decide to go country by country, take the national route, and apply for protection of his trademark in each country. For that, he will need to follow the procedures that are in each country and to adapt to the language, to the rules there, maybe hire an attorney, pay the fees in the local currency. There are other options like the regional route. If he knows that he's going to expand into a territory that is contained and has a specific regional trademark registration system, like as EUIPO or the Benelux office, he can go and just apply there. Now, if he has plans to expand further, to go international, but it doesn't immediately, maybe it's in the midterm or in the long term, he's planning to go to countries beyond that, then he may be interesting for him in using the Madrid system. So when he will seek protection through the Madrid system, he will be able to access multiple markets in different regions of the world. It's a flexible system that avails someone to start maybe with one country or two countries or three countries, and as the business does better and expands further, he can add countries to that existing registration. That system also is suitable if you have a limited budget to expand, to invest on registering your mark and monitoring that. As we charge fees are more limited, there are some savings because of translations, because of national procedures. You don't have to follow to that extent, that you can just monitor from a bit from the Madrid registry. And so at the end, it's really cost effectively for users. So which coverage can someone obtain through the Madrid system? So today we have 150 members. That includes the European Union and DOAPI, the African Organization for Intellectual Property. So all that together covers 131 countries. So it's really global. Lately, we had accessions from a number of countries. It's growing really fast. We had the accessions of Jamaica, of Chile, Cabo Verde, among others, also of Qatar earlier this year. So it's been growing a lot over the past years, and it keeps growing as we expect it to go further and to these countries that are a bit more red and include countries rather soon like Saudi Arabia, Bangladesh, or Sri Lanka, among the member states where someone can obtain protection through the Madrid system. So these are countries are working on the preparation to join the Madrid system, so one can then also accede to these markets through as a single application through Madrid. So how this works? So as I've been saying, there is a single application in one language. The current language of the Madrid system are English, French, and Spanish. Up to 131 countries. This set of fees, so we will see later, is paid directly to EUIPO in Swiss francs. And this is how the Madrid system works. This is a really like a lookout on how it works. Everything starts at the first stage. We have a trademark applicant, the owner of a mark that has a mark applied for or registered in his country of origin, in his local IP office. Through that IP office, he can file his international application, and that office will forward it to EUIPO. At the EUIPO stage, we will check all the formalities in that application. We will check the classification and do all the other checks. We will register this mark. He will have an international registration, and in the countries where the trademark owner asks for protection. And it's these offices that grant or refuse protection to a trademark. And I'm going to go now through every stage in a bit more detail, so you have a better understanding of how the Madrid system works. So in stage one, we have the applicant that has to go through his office of origin, his local IP office where he will have a basic mark. The first thing to decide who can use the Madrid system is we need what we call entitlement. It's the right to use the Madrid system. It's a closed system and not everyone is able to use it. So to be entitled to use the Madrid system, the trademark owner needs to have a real and effective industrial or commercial establishment in one of the countries of Madrid. He can also be a domicile in one of these countries or be a national on one of these countries. If one of those three conditions, either establishment, domicile, or nationality are met, he's able to use the Madrid system. So that's the first thing that someone will need to clear before starting using the Madrid system, if he has the right to own a trademark through the Madrid system. The second thing we need is to have a mark already in your local market. In that country in which you have this right, this entitlement to use the Madrid system, the applicant also
Sorry, Aurea, we have lost you a bit. We cannot
have
hear you
what
very
we
well.
call a basic mark. Of the same mark, he wants at the international level. Sorry, how far go?
Now we can hear you.
Can you hear me better now?
So you can repeat, please, like your last two
Yes, sure.
sentences.
Yes. So I think I was saying once someone has make sure he has the right to use the Madrid system, he has an establishment, he is domicile, or he's a national of a member of a country that's member to the Madrid system, he's ready to start using the Madrid system. That's the first condition. And the second condition to be ready to use the Madrid system is to have what we call a basic mark. That basic mark, it's either an application or a registration of the same mark that the trademark owner wants to apply for at the international level. Once we have these two conditions, we have an entitlement, the right to use the Madrid system, and we have what we call the basic mark. The owner of that trademark is ready to apply for an international registration. He will apply through this registration through the IP office where he, or in the country where he has that basic mark and where he fulfills the condition of the entitlement to use the Madrid system. So that local IP office will receive the international application, that it's not sent to EUIPO directly, it has to go through that office. EUIPO can only receive the application through a national office or a regional office that it's member to the system. These offices checks the international application and makes sure that the details in the international application match the details of the mark they have at the local level, either the application or registration of the mark. So it's the same holder, the same mark, the same logo of the mark, and that the goods and services of the international one are matching the ones in the basic mark, not exactly matching as the same wording, but at the scope. So the international one cannot go broader than the national one. Once the office is satisfied that all of these conditions are met, the local office is ready to certify the application and send it to EUIPO and move to the next stage. So at that time, the fees for the application are also due. And this is the fees, or how the fees payable for an international application are calculated. We have a first step that everyone needs to pay, that it's the basic fee. And we have two sorts of basic fee. We have 653 Swiss francs if the reproduction of the mark, if the representation of the mark is in black and white. If we have a mark that is in color, the fee is a bit higher, and it's 903 Swiss francs. So this is the first basic fee, is either one or the other. To that, we need to add what we call the standard fees. And it's normally, depending on the number of classes that you have and the number of countries, we will have some fees. So the standard fees, it's 100 Swiss francs per country, per designation. You add in an application, and it's 100 Swiss francs for each class beyond the third. So we start adding that only if you have more than 3 classes. Some countries thought that this standard fee for them was either too much or not enough, and they have declared their own individual fee. So while the standard fee, it's the fee that will be distributed to the countries where you ask protection, some countries opt out and have their own fee established that normally matches the cost at the national level. And this individual fee is set by each country, and of course it will depend which countries you select. There is a list on our website, or we even have a fee calculator. So that one said, that is the normal procedure for calculating the fees for an international application. We also have some discounts regarding only the basic fee, and that's applicable for applications that start from least developed countries. It's a limited list of countries that it's available also on our website, where you can check like these applications originating from one of these countries get a significant reduction on the basic fee. So how to file this application with EUIPO? So there is a lot of information that will help you prepare. First, we have what we call as application simulator, that it's a tool that can help one establish if he has the right to use the Madrid system and through which office, and sharing the contact details of this office to facilitate that. We had also the fee calculator that I've just talked about. It's a tool that can help users estimate how much it will cost to file for them an international application, depending on their origin and the classes they protect and the number of countries, or which specific countries they want protection in. Then we have plenty of information about procedures in different member states that can be helpful. For example, particularities that someone has to take into account when preparing the list of goods and services in the international application. For that, we have the members profile, and we also have tools that help you configure the list of goods and services. So you can use our tools to compile the list of goods and services that will be that can be acceptable, not just at the EUIPO level, but also in some designated offices. Altogether, it's just preparatory information to file an application. And once you're ready to file the international application, we have online forms that also will guide you through the process of filing this application. and integrate also some of the tools. So the fees will be calculated automatically. You will also have assistance to building your list of goods and services. So that facilitate life of applicants when filing an application. So that will work for some offices. Other offices have decided to have their own system for online application or their own forms that matches the content of WIPO ones. So it will be also useful to check if you ever have to file an application, to check with your local offices what is the right procedure for you to follow to start using the Madrid system. So we move now to this stage number two in the process of applying for an international trademark application. And it's a stage that we are now in WIPO. Your process, all your procedures at the level of your local office were successful, and the local offices sent the application to WIPO. At WIPO, we conduct what we call formalities examination. We will check that all necessary information in the application is there, but we will also review the classification of goods and services, which is one of the more important steps. We will make sure that the classification is correct according to the NIST classification. If there are any problems in that application, either because some of the formalities are not met, the classification is not right, or the fees have not been paid, any missing or defective information in the application, WIPO will raise an irregularity. It will notify the holder and will notify also the Office of Origin. And it will give the opportunity for the holder, for the applicant at that point still, to remedy these irregularities. We'll have a standard time limit of 3 months to make sure that the applicant sometimes can directly reply to WIPO, but depending on the nature of the irregularity, the reply will have to come through the Office of Origin. So once an application, either from the beginning or after the irregularities have been remedied, meets all the requirements, it is recorded in the international registry. At this point, WIPO gives an international registration number. We have a certificate of registration that is sent to the holder, and we notify all offices in the countries where protection was requested, and we inform them that someone has asked for protection. So at this point, we don't know if that international registration, it has a number, it's a registration, the holder has a certificate, but we don't know if protection will be granted or is granted in any of the countries. So at this stage, an international registration doesn't have effective protection nowhere. It has the potential of obtaining protection, but that's not sure yet. So protection is not known at this stage, even if someone has a certificate of registration and an international registration number. This part is a bit confusing sometimes. That's why I like to really clarify. There is no protection at this stage. It's potentially started. So what we have is an international registration number. It's a real registration, but no decision on the protection. So this real registration, from the moment you get the certificate, you have an international registration number, one can start managing his international registration. And the management of that registration is centralized at WIPO. So if for any reason you have to change your name because you change address, that can be done in WIPO with a single procedure in WIPO, and it will be notified to all the countries where your mark has effect. So all the countries where we have sent a notification saying, or where you selected them in the application saying, I want protection there. That it's the same if you sell your mark, if you have a change in ownership, or if you would like to renounce some countries, say I was interested in this country, I'm no longer interested, or I requested 3 classes in this country, maybe I went too far, I want less. So I now just want 2 classes in this country. So all of that can be centralized at WIPO. The other thing that is centralized, for example, is if you selected 2 or 3 countries in the application, let's say you have asked for protection in 3 countries, your business is doing better now, you will like to move and ask protection in more countries. So you can just expand the protection of your international registration and add more countries to that registration. At the moment you need to renew your mark, that will also be centralized at WIPO. So everything that has to do with changes to international registration, renewal, subsequent designation, anything is done centrally at EUIPO, and EUIPO informs all offices concerned. So it really facilitates life for you, for trademark owners, and it's just one procedure that can have effect in every single country when you ask protection, and that can be one country, but it can also be 131 countries. So for that, EUIPO has plenty of e-forms specialized for each request you have to make. So you can use expand protection to add countries, you can limit the goods and services, you can appoint a representative with EUIPO. Everything can be easily done online through our online forms. So from the moment EUIPO issues this certificate of registration, where you are able to start managing your international registration, EUIPO also notifies all the countries where this trademark has effect. So all the countries you listed in the international application get a notification saying we have an international registration that has asked for protection in your country. So from that moment, from the date of international registration, has the same effects in registration as if a mark has been filed directly in the office where you ask for protection. So these offices will have certain time limits that we will see now to say whether they grant or refuse. And if they don't say anything, your mark will be protected. So it's all these offices where you ask for protection in the application that have to go and do substantive examination. Whatever are the procedures on the international registration, between 12 and 18 months. So the standard time limit is all offices have 12 months to say, yes, I protect or I deny this mark in my country. And some offices have asked for extra time, and they can go up to 18 months. So, but that's a known time limit. So you know that if you file an international application, you will get a reply, whether your mark is granted or protection, either with up to 12 months or up to 18 months. So this decision will be notified again, will be centralized again in EUIPO. The office the local offices that's granting or refusing protection notifies EUIPO, and EUIPO notifies the holder. So if an office grants protection, everything is fine. They issue a statement of grant of protection, and you have you know that you have protection in that country. Now, if the office refuses protection, either totally or partially, EUIPO will notify the holder this decision, and the procedures that will follow that refusal are not at EUIPO, they are at the local level. At that point, a user, an international holder, the holder of an international registration has to go to the office that refused protection and defend his rights there. That's what we call a bit of a national phase, that the international user has to go to that country and defend his rights. And when a decision is taken, a final decision about the status of that mark is taken, that office will notify by EUIPO with the final status that either protection was partially granted or was totally refused. And that will be recorded in the international registry. So all the information about what is the status of protection in each of the countries where someone asks for protection are also centralized at EUIPO. So a user will find in EUIPO, in the international registry, what is the status of protection of his mark in all the countries at certain points on time. So after 10 years of his international application, he will be able to renew, knowing what's going on in all these countries centrally at EUIPO. So he will renew at EUIPO, and again, EUIPO will inform all countries. So that's really big lines on how the international registration procedure starts. It's not complicated, I would say. It's just knowing exactly what to do at each moment and monitoring the situation. So this is another view of the decisions that can be taken from the office, that maybe it's a bit more easy to visualize. So it starts with the application that is registered at EUIPO, and EUIPO notifies every country where the holder asks for protection. So from the moment these countries are notified, they have up to 12 or 18 months to send to EUIPO either a statement of grant of protection saying I protect this mark, or to refuse protection. When they refuse, once the procedures of the refusal have finished, once they have taken this final decision about to granting or refusing protection, they will send to EUIPO a final decision. If they miss the deadline of 12 or 18 months to grant or to refuse protection, we will understand that protection is granted by tacit acceptance. Then it can happen that at the national level, there are other procedures like an invalidation procedure or any other actions at the national level that may result at the later stage in a new scope of protection for the trademark. So at any point, an office can notify WIPO this new status of protection. It's what we call a further decision of there is a more severe consequences and a mark has been cancelled at the national level. They can notify WIPO an invalidation. So that status is also reflected in the registry. So these are the main decisions offices at the national level can take that will have an impact on the international registry, and that office must notify WIPO. So the status of the mark in the international registry is aligned what's going on in their countries. So today, WIPO has over almost 2 million marks registered. It's a really old system that started in the 18th century, in the 19th century. The oldest mark we have today registered in the registry dates 1889. It was first registered in Switzerland and then internationally in 1893, and it's still active. We reached some years ago our mark 1.5 million. It was a Colombian mark that was registered internationally in 2019. And last year we had our mark that was 1.75. That was an American mark. So this registry is growing. And so we have 1 million marks, but that's the number of marks registered at the WIPO level. But these marks, each of the marks is protected in several countries, it's what we call designations. And we are now managing over 7 million active designations, so which is with plenty of decisions of status and big volumes of things to manage. The Madrid legal system, it's based on 2 international treaties. We have the Madrid Agreement and the Madrid Protocol. The one currently in use and it's applicable to everyone. It's the Madrid Protocol. That's where the name of the Madrid system comes from, because it was an international treaty set in Madrid. This Madrid is further developed, this protocol is further developed by regulations that specify in more detail all what can be done or not done, and it's even more detailed in administrative instructions. Another part of the Madrid legal framework, another really important part, are the laws and regulations of each member of the Madrid system. As in WIPO, we don't grant or refuse protection. Whether a mark is refused or not will depend on the national procedures. And that's why we say that the national laws and regulations of each country are also part of the Madrid legal framework. This legal framework is also reviewed constantly. The Madrid, especially the Madrid regulations and the Madrid administrative instructions, are subject to changes and to improvements, also to adapt to how life changes. And this is done through annual meetings of our member states, of all countries that are part of the Madrid system meet annually to discuss how to better improve the system, what things can be changed or adapt to improve. And these recent years, we had a lot of changes regarding to the possibility of having electronic communications and using email addresses. Our renewals procedures have also been improved to allow more time for users to renew and clear information to simplify all the renewal process. We are now accepting also new means of representing marks, meaning that we accept marks in the form of videos, of sound, of plenty of other formats, also to align with new times. We are currently implementing new adapted rules regarding refusals, regarding better information when offices refuse a trademark, so to have minimum time limits for them to refuse, and more clear information about what is the time limit for the user to reply to that refusal at the local level. And we've also been having changes to what's called a replacement procedure that is a bit more advanced, but that allows a holder to replace an existing mark at the national level with a Madrid designation. So this annual meeting where countries meet to discuss how to improve the Madrid system that took place last week. And several things were discussed, and it's always interesting to be up to date. And they discussed some improvements to the individual fees. That's the fees set by each country regarding the cost of an application or their own designation. So adjustments to take into account fee exchange rates will be made. Then we'll have further requirements regarding email addresses to ensure that the international registry communicates fully electronically with all its users. And there are two topics that will be discussed again next year. There are dependency, that's a link we have between the basic mark and the international one, and also the possibility of introducing new languages to the Madrid system. And now we are currently discussing the possibility to introduce Chinese, Arabic, Russian, and also Japanese, Portuguese, and German as working languages of Madrid, or any other possibility. And just some statistics for you to have an idea of a bit more about how the Madrid system works. It's a growing system. The number of applications, of international applications over the years overall, it's been growing a lot. The fluctuation, the difference year by year, sometimes is a bit more positive, and then also as it happens also at the national level, some years it's better and other things that may influence that. But overall, the tendency is a growing number of applications year by year. We have offices that apply more than others, of course, and our top filing offices, the ones from which we receive the biggest number of international applications, are the US, Germany, China, France, the UK, or Switzerland, which the applicants from those regions are applying or using more the Madrid system. So these applications, international applications, where they ask protection the most, where people seem to have more interested in protecting their trademarks, it's in the UK, the European Union, the United States, Canada, or China, among others. Then this is a slide about the general profile, who uses the Madrid system or how they use it. So we are now seeing that last year, we had the number of users that only use the Madrid system to obtain protection in just one market. So the average number of designations moved to 3 or 4 some years ago, just to 1. So we are seeing that at first they just apply for one country, but then once they have the registration, they apply for more. So they just start small, and then immediately as they feel maybe a bit more secure, or they have start exporting to other places, they will add countries to that designation. In general, they apply ask for protection between 2 and 3 classes. And while this cost seems a bit high, most of them pay less than 3,900 Swiss francs to file an application. So if we check the number of holders, we have a big, like 64% of our holders only own 1 registration. We have 60% that own 2 registrations, and then the number grows exponentially. So it's more rare in the registry that people own like more than 500 trademarks. So it's small users. It's users that own 1, 2, or 3 trademarks that are using the Madrid system. So it's not only big companies that can use the Madrid system, but the Madrid system and benefit from its advantages is also like small users that have 1, 2 trademarks. That's always a slide of a lot of interest. It's what are the classes that are protected the most in the Madrid system. So it's class 9 for computer and electronic. It's also services for business in class 35, technological services for class 42, laser education and training services, and then pharmaceutical products. So these are the classes that are more often seen in our applications and the registrations we have. And finally, it's just a slide about if you want more information about the Madrid system, we have a lot of information on our website. we have these Madrid system webinars when you can get just specific webinars on topic by topic to get deeper in anything you may be interested to. We have how-to videos and tutorials if you need to file an application or to file a subsequent designation with us. We regularly publish news about the Madrid system when a country joins or if there is a change in our legal framework that may be of interest of users. But we also have a YouTube channel and historical podcast where you can find extremely detailed information about the beginning of the Madrid system until today. And of course, we have like success stories like of users sharing their experience when using Madrid. And for any questions, I have now some minutes probably, but you can also contact us anytime and we will be happy to reply. If you ever encounter any problems with the Madrid system or would like to file, just you can contact us. So that's it for me.
Thank you very much, Aurea. Before we had also your colleague connected, but now it's out. So I don't know if maybe he has technical issues or something. We have 10 minutes before the closing of your session. So I think we can give the floor to any questions that maybe our participants have.
Please.
So is there any question? There was a question actually, was the duration of the registration of the Madrid system, but someone else replied 12 to 18 months. So I see now a question. So what specific skills and experiences should young professionals focus on developing to enhance their applications for careers at EUIPO? And are there any particular programs or initiatives that EUIPO offers to support their entry into their organization? Well, not really related to the topic, but maybe you can reply.
Sure, I can provide some information. Look, at EUIPO, we have an internship program for I think it's for students in general. It's on our website. We have a roster of internships, I think it's called, where everyone can apply. We also have recently, I think it's now 2 years, we have a young professional program. And we have colleagues, that join us for a couple of years that it seems really, really interesting. And they are have a specific project over 2 years, and they are working a couple of places, in different divisions in EUIPO. That seems a really interesting program. And
we lost you a bit. We cannot hear you very well.
Opportunities just open to professionals. Can seem a bit, sometimes it's difficult, sometimes it's easy. There is plenty of you now that come to my mind. These two, just any of you who is interested to just check in our website, the opportunities available and information there. I don't have any particular advice.
No, don't worry, actually, you're not here for that, so it's fine.
I think we have people in EUIPO that can help you with that. If you have any questions also, you can contact EUIPO, and I'm sure my colleagues in HR or in other departments will be able to provide more detailed information about the hiring process and how this works. But yes, please reach out and check the website.
Sorry to intercept, but I think we also have Imane in the chat in here with us from EUIPO Academy. So I don't know if you have any more insight on this question, Imane.
Hello, everyone, and thank you so much, Aurea, for your wonderful presentation. I think we all gained a lot of insights on this topic. And yes, to answer this question, so I think Aurea really explained it well. Everything is on the EUIPO website. You can apply, and you don't need to be fearful of not having enough IP knowledge, because the purpose of these internships is actually to gain the knowledge as well. And it could be any internships. It could be from the media and news division to the PCT, which is on patent. So depending on what you want to learn at the EUIPO, you can really just apply to the roster of internships. We also have the Young Expert Program. We have fellowships. There's a lot of opportunities here at the EUIPO. So you just need to be, be fearless and apply, and you never know.
Thank you so much. Exactly. We have 2 more questions, and we have 5 more minutes before we go for the lunch break. So the first one is, I was wondering if EUIPO responds to someone above them. And if yes, who or is it ultimately supranational organization based on the cooperation of all the countries involved?
I'm not sure I'm getting this question.
Well, if there is actually, I would say that pretty much it's not even in the sense of us, in the sense that they're international organization, EUIPO, and in our case, for example, we're of the European Commission, so it's not in reality that one office is above the other one. So this is actually the question, whether there is another organization or institution, which is, let's say, like higher authority of EUIPO in case that EUIPO needs to respond to someone. This is how I understand the question.
Yes. At the EUIPO level, I will say the work that we do in EUIPO, for example, in the registries, it's different. So if it regards HR matters or the EUIPO work in general, yes, some of the other UN agencies may be able to help with some of this work or to have an opinion on that. But at the level of the registries, for example, in the Madrid registry, we do formalities, we maintain a registry, we have certain obligations according to our treaties, we have certain obligations according to the Madrid treaties, others, as we will have other sessions these days, have obligations according to their treaties. But as I said, we don't enforce rights, we don't grant or refuse protection. So if it relates to a trademark, the end work, whether there is a problem in one country with a specific registration, it will be for the judicial authority in that country to decide. And once they have finished that national procedure, they will inform back EUIPO. So it's a bit, things start in the country and also finish in a country, and we are centralizing this information in EUIPO. So there will be no something really beyond EUIPO. It's a collaboration with offices, but the national judicial authorities will have the last word whether a trademark is protected or not in their territories. We don't intervene in that. We just take note of their decisions.
Thank you, Rea. If I'm not mistaken, I just saw your colleague also joining on being 10. I don't know if you're here, you can hear us now. I just saw him before joining. Yes, he's here. Hello, good morning. I don't know if he can unmute himself.
Yes, I hope now. Good morning, everyone. Good morning, George.
Hello, good morning. Thank you very much.
Thank you for giving me the opportunity. It's a great pleasure to meet with the students who are interested in IP. I guess my colleague here has already finished her presentation.
Yes, we are now in the session of questions and answers. We have still 2 more minutes before the lunch break. I would like also to raise the other question that we have received now. So what happens if someone fills registration for a trademark with EUIPO and the Madrid system at the same time, and one of them agrees to the registration and the other one denies it?
So as I said, in EUIPO, we don't grant or refuse protection. So someone can choose to apply through EUIPO for international registration and ask for protection in the European Union of a trademark. And maybe someone else at the same time is also applying directly in the European Union for that same mark. So it's going to be the office in Alicante, the EUIPO, who decides who gets protected in their territory. And once they have a decision, if it's to accept the international mark, they will inform EUIPO that that mark has been accepted. And if it's to refuse the national mark in favor of protecting the other one that has to go directly to them, they will also inform EUIPO. So, but that's a procedure that it's the EUIPO how would follow its regional procedure to decide which mark gets protection. So that can happen. It can happen with the EUIPO, but it also can happen with any other country. It's really the national procedure as any other trademark, and they will just have to inform EUIPO at certain points. So there is no conflict. EUIPO will not grant or refuse protection. We just facilitate that registration to reach a country and also centralize the decisions thereafter. So we facilitate the management of that registration at the international level.
Thank you so much, Aurea. I don't know if Hongbing, sorry if I'm not pronouncing your name correctly. I don't know if you also want to add something on what Aurea just mentioned.
Yeah, I think Aurea has given the right reply. She has been working in our legal division for so many years. But from operational point of view, I always treat member offices as two roles. One is as office of origin, another is as office of the designated contracting parties. That means designated office. So for these two roles of a particular member office of the matrix system, they are different. Okay, so when we talk about seeking protection of trademarks, I do believe personally, I do believe that the three-step process, filing of the international application with the office of origin, examination and registration of the application, the international application by WIPO, as well as the examination and decision by the DCP, we call it Designated Contracting Parties Office. All the three steps are equally important. At any moment or at any stage or phase, some of the applications might encounter the possibilities of being challenged or being modified. So the users, some of the users really, they abandon. That means they voluntarily give up the process. They stop the application process at a certain point. We do have such kind of cases. But theoretically, not theoretically, I mean, in practice, we have most of these international applications go through all the three stages successfully. So that's my answer. Thank you.
Thank you so much. And Imane, from your side, if you want to add anything. You're muted.
Well, I'm not sure that I can add to the very relevant and very right responses from Ms. Plana and Mr. Chen. But if I may conclude on this topic, I think it's really great that the students are really engaging and they have questions, and I'm really happy that they really gained the knowledge as well from your division, Mr. Chen and Ms. Plana. So thank you very much to both of you, and thanks to the EUIPO for providing this amazing opportunity to the students to learn more about IP.
Thank you so much to all of you. We have one more question, but as we are 2 minutes late, I don't know, it's really up to you if you would like to raise the last question. Okay, so the last one is, would the decision be based on the filing date, eventually time in such case, or do they both, I suppose it's related to the previous one, to the EUIPO and the Madrid system, or do they both go through examination and then a decision is taken?
Well, look, the date of, I didn't touch on that, but the date of international registration, if everything goes well, is the date where the user applied in his office of origin. So the date he filed the application, the international application in the office of origin, is the date that will be carried on to this international registration. So from that date, protection is supposed to be the same as he filed a national application. If there is any conflicts with that date at the national level with any other trademark, every office has its own way of dealing with that. So it's, again, anything regarding the protection of a trademark will be solved by the office and which protection is requested. It's really unfair situation that they will be just dealing with one day, but anything, the only thing that I can say is the international registry. The international registration keeps normally, if everything goes well, and it's like almost all cases, keeps the date of the office of origin, and also it includes any right of priority they may claim in the application. So all of that together has to be considered by the office where protection is asked, by the designated office, to decide if they grant or refuse protection. So then it could be a matter of any prior rights, of opposition, and it will be every office where protection is asked that will deal with that in their own, according to the laws and practices.
Thank you very much. And Homing, from your side, anything additional to what Aurea said?
Not really. It's a very good answer.
Okay, good. Thank you very much. Thank you again very much to both of you. I mean, Iman just left, to all of you from EUIPO participating in this program. I think it's very nice that everyone can have a full insight, actually, of the IP scheme, also from the international scope. So thank you again for being here today and for your presentation. For our participants, now it's time for lunch break. I think everyone is a bit hungry and tired. So we are going to meet back at 2:15 sharp here with our next presentations on absolute grounds for refusal. So thank you very much, everyone, and see you back at 2:15.